सर मेमो 1 मिनट सर मेमो
वो देते कर लिए
अनेक बात बैठो अरे दोनों फ्रेश बैठ रहे फ्रेश संडे करेगा तो क्या करूँ उसको
मन मारो तुम्हारे
करके उसको करेंगे
मन क्या ऐसा ब्रेक मार लेगा
सामने करेगा ना हम लोग एक बार तो ठहरो एक मिनट आगे उसको घर में निकाल
हमारे भाई साहब के पास
चलो
ಸರ್ ಕುಂಭಮೇಳ ಹೋಗಿದ್ರೆ
ಹೋಗಿದ್ದೆ
ಏನು ಕೆಲವು ಬುಕ್ಕಿಡ್ರು ನಾಗ ಸಾಧು ಜೊತೆಗೆ ಅಗೋರಿಗಳ ಜೊತೆ ದೀಕ್ಷೆ ತಗೊಂಡ್ಬಂದಾರಂತೆ
ಇಲ್ಲಿ ನನ್ಗೆ ಯಾಕೆ ಸಂಬಂಧ ಸರ್ ನಾವು ಹೋದ ಮೂಡದ
ನೀವೇ ದೀಕ್ಷೆ ಸೇರ್ಕೊಂಡಿರಿ
ಬೇಕಾಗಿಲ್ಲ ಬೇಕಾದವ್ರು ಹೋಗ್ತಾರೆ
वो क्या करेगा
पूरे उठते ನೀವೇ ಹೋಗಿಲ್ಲ
ತುಡಿತ ಬಾಳ ಐತೆ ನಾವು ಸಪ್ರೇಟ್ ಮಾಡಿದ್ದೆ ಸ್ಪೆಷಲ್ ಐತೆ ಅಲ್ಲಿ ನಮ್ಮ
ಸಮಾಜವಾಗಿ ಖಿಲಾಫ್ ಇದ್ದೀರಿ ನೀವು ಹೋಗಿ ಮಾಡ್ತೀರಿ
ಧನಂಜಯ ಅದನ್ನ ಯಾಕೆ ಇದನ್ನ ಕೊಟ್ಬಿಟ್ರೆ ಅಲ್ಲೇ ರೆಕಾರ್ಡ್ ಮಾಡ್ಬಿಡ್ರಿ
ಇದು ರೆವಿನ್ಯೂ ಸಂಘ ನೀವು ಸರಸ್ವತಿ ನೀರು ಆ ಜಾಗ
ನೀವು ಅಗೇನ್ಸ್ಟ್ ಇದ್ದೀರಲ್ಲ ಇದಕ್ಕೆ ಅಖಿಲೇಶ್ ಹೇಳೋರು ನೀವೇನೋ ಹೇಳ್ತೀರಿ ಅಂದ್ರೆ
ಅವನ ವಿಚಾರ ಕಂಪ್ಲೇಂಟ್ ಬಂದ 3 ಸಲ
ಅಂತಾನೆ ಮಂದಿಗೆ ಯಾಕೆ ಮಾಡಬೇಡ ಅಂತಾನ
ಮಂದಿ ಮಾಡ್ಕೊಂತ ಹೋಗಿ 3 ಸಲ ಹೋಗಿ
ನೋಡ್ರಿ ಅಖಿಲೇಶ್ ಬೇಡ ಅಂದಾನ ಖರ್ಗೆ ಸರ್ ಬೇಡ ಅಂದಾನ ಮತ್ತೆ
ಅಲ್ಲ ಹೇಳಕ್
ನೀವು ಅಲಯನ್ಸ್ ಇದ್ದೀರಿ ನೀವು ಅಲಯನ್ಸ್ ಇದ್ದೀರಿ ಮೊನ್ನೆ ನೀವು ದಿಲ್ಲಿ ಎಲೆಕ್ಷನ್ ಕ್ಯಾನ್ವಾಸ್ ಮಾಡಿಲ್ಲ
ಯಾರಿಗೆ
ಕೇಜ್ರಿವಾಲ್ ಮಾಡಿಲ್ಲ
ಕೇಜ್ರಿವಾಲ್ ಮಾಡಿ ಕೇಜ್ರಿವಾಲ್ ಕಾಂಗ್ರೆಸ್ ಗೆದ್ದು ಬರ್ತದ ಕಾಂಗ್ರೆಸ್ ಏನು ಬಿಜೆಪಿ ಮತ್ತು ಎಪಿಗೆ ಡಿಫರೆನ್ಸ್ ಎಷ್ಟು ಓನ್ಲಿ 2%. ಇವ್ರು ಎಂತ 5% ಒಂದು ಕಾಂಗ್ರೆಸ್ 56% ಜೀತ್ ನಮ್ದೇ ಅವನದೇ ಮತ್ತೆ
ILR
ಅಲ್ಲ ನಮ್ಮ ಹೈಕೋರ್ಟ್ನ ಅಡ್ವೊಕೇಟ್ ಕೆಲವು ಏನು ಅಗೋರಾಗಿದೆ ನಾಗ ಆಗಿದೆ ನಿಮ್ಮಲ್ಲಿ ಹೋಯ್ತೆ
ಜಸ್ಟ್ 12 ನಂಬರ್ ಒಂದು ಕ್ಲೋಸ್ ಆಗಿದೆ. ಇದು ಒಂದು ಸ್ಟೇಟಸ್ 12 ಆಮೇಲೆ
ಯಾರು ಗೊತ್ತಾಗ್ತದೆ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ವಾಯ್ಸ್ ಕೇಳಿಸಿದೆ ಮೇಡಮ್?
ಹಾ ಸರ್, ಕೇಳ್ತಾ ಇರೋದು.
ಓಕೆ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಸ್ಟಾರ್ಟ್ ಆಗ್ತದೆ ಈ ಕಡೆ
ಮೂರುದಿಲ್ಲ ಗೊತ್ತಾದ್ರೆ ಗೊತ್ತದ ರೂಲಿಂಗ್ ಕೂಚಕ್ಕೆ ರೀಸೆಂಟ್ ಆಗುತ್ತೆ. Fresh matters. RFA.
RFA first man.
Fresh matter RFA. Fresh matter RFA.
Lords, one writ appeal. Check. Monday. Lords, one writ appeal, my lords, wherein the petitioner came in contact with the live electrification wire, my lords. And your lordships have, one of the reported judgment, my lords, dealt with that issue, whether suit is maintainable and writ is maintainable. And that judgment was relied on in this particular, my lords, single judge, and awarded the compensation. Against that, they have filed the writ appeal. And your lordships, that matter was come up before this court, and your lordships directed me to verify that whether the writ appeal is filed against your lordships order.
Monday.
Adu writ appeal dispose agide.
Lords, fresh MFA matter, my lords. Kindly on Monday, my lords.
MFA fresh matter, kindly have it Monday, my lord. Monday.
One matter, my lord, wherein husband is in appeal, matter is compromised. Parties will file, my lord, 13(1)(b) application, mutual consent, may be taken up on Monday.
MFA meter ಮಾಡಿ ಕ್ಲಬ್ ಮಾಡಿಸ್ಬೇಕು ಅದಕ್ಕೆ
ಕೊಡಿ.
Page wise
One
adjustment. Page number 3, till number 8 to 10. Number 11 and 12, page number 5, till number 30.
Serial number 11, my lord. The Subhas Malapur advocate has been to Kumbh Mela. He asked me to take time, my lord.
At request, relist the matter. Yes.
Till number 1, Deepak V. Bharat.
Close. Lord, the two appeals have been filed.
What is the office objection?
Annex.
Office objection 1 is court fee.
Lord, that has been corrected.
Huh?
One.
So far as office objection raised regarding furnishing of legible copy of annexures R1 to R5. That counts
Yes,
for
ma'am.
the
Respondent has produced,
appellant.
Lord, respondent had filed.
The legible copies will be produced at the time of hearing if called upon.
My Lord,
Subject to such undertaking, office objection kept in abeyance. Yes.
Lord, both the writ appeals have been challenged, calling in question the order passed by the learned single judge. Lord, the brief facts of the case are that, my Lord, the appellant herein is a owner of land.
My lord, Anand Jagirdar is the contesting respondent. He is not here, my lord. Already lordship has granted stay. It will be taken up on Monday or Tuesday.
Only
Is there, my
submission,
lord.
my only submission is that, my Lord, the already structure is there, my Lord. Amalgamation order, which was already granted by the authorities, my Lord, it was time being suspended, thereafter revoked. Again, my Lord, entertaining the complaint of the fourth respondent, my Lord, that has been cancelled, my Lord. That was questioned before the learned single judge. Learned single judge at first instance, my Lord, in writ appeal, in first writ appeal, had remanded back the matter to second respondent. That order was challenged before this court, my Lord. And during the pendency of that, this writ appeal, my Lord, another impugned order has been passed by the authority that the appellant do not have any title. Lord, when the civil suit is pending, filed by the respondent, fourth respondent.
25th.
Yes, Anand.
Relist. Same stage on 25th.
Yes, Lord, my Lord, shall granted stay of amalgamation order. But since, my Lord, already structure is there, 90% construction has been done.
See, so let him come.
Oh, bless.
Till number 2, Jagadish Shastri.
My lord, in this case, in a similar set of facts, my lord, the principal bench has already held, my lord, in respect of salary in the contempt, it cannot be urged. My lord, the contempt was filed only in respect of, if lordship looks at page number next, that is next. There was a stay order, my lord, not to review the complaint from service.
Till number 2.
Lordship, serial number 2, I am advocate for the complaint, Lordship. My lord, in this case, my lord, last time court has directed to pay the salary, Lordship. Kindly
Not
see the order
directed,
sheet, Lordship.
Not directed to say what regarding the, as he has not worked for 2 months, salary cannot be paid, my lord. And already the principal bench has taken a view, my lord, that cannot be raised in the contempt proceedings.
No. What is
Lord, last time this court
My lord, the interim order was, my lord, if lordship looks at page number 16 of the contempt petition. Page number 16.
Lord, they are reinstated, mean, my lord, they are taken back.
Lord, in the meanwhile,
not
respondents are directed not to disturb the petitioner from the post held by them as FDA, assistant cook and cook till the next date of hearing. My lord, if lordship looks at the order sheet of the learned single judge, interim order was not extended. Irrespective of that, we have reinstated them, my lord. Now, the contempt petition would not survive, my lord, in view of they being reinstated.
So you have reinstated.
Yes, my lord, that is already there, my lord. Now they are asking for salary. Salary does not.
Which period?
For 2 months, the period they were they have not worked, my lord, from the date of removal till reinstatement. Even otherwise, my lord, if lordship looks at that
you seek for the single judge in the pending proceedings.
Yes, already
how we can look into in the contempt proceeding.
Lordship,
And
the
even
court has
otherwise,
directed
most-
appeal petition.
Contempt direction baralla. In the single judge where the matter is pending, you seek for appropriate relief there.
Matter is not pending. Matter is disposed of. Matter is disposed of. The directed not to relieve, my lord. They instead of their relief, after that, my lord, they reinstated, but society has not paid, my lord, last 2 months. Here. That is I'm seeking only because of their fault only I get it last lordship. Now matter is not pending, lordship.
Where is the direction to pay salary?
My lord, in the earlier court has passed the order annexure F. Kindly say annexure F.
No, you are filing contempt with respect to the interim order passed by the single judge, isn't it?
Yes, lordship. That is reinstated. Now reinstated. That is reinstated.
That interim order at page 16 says you have to reinstate. Where is the direction to pay salary in that order?
Not that is not order, but therefore because of earlier court has annexure F, court has directed in the contempt petition annexure F. I kindly say annexure F, lordship. Where they paid the salary, the similar situated candidate, they paid the salary, but they are not paid now. Me today.
Even otherwise, lordship looks at the order sheet of the learned single judge. Interim order was not extended. I have produced the order sheet also.
No, we can't enter into contempt of contempt. You seek appropriate relief by appropriate proceedings, not in the present case.
Milord, the kindly see the order sheet of last order sheet of this court. Of course, has observed the order sheet. Kindly see the order sheet of this court. Last time court has observed.
To make submissions, my lord, we are not. Sorry, my lord.
No, order dated
last before this before this posting today, last order, final last order.
He has been reinstated, there ends the matter. So you have filed an affidavit.
Lord, it is already taken record, my lord. The court has this honorable court has already taken on record that is reinstated. And even I have produced the order sheet of the learned single judge, my lord. There was no any interim order as on the date of his removal. Already has been noted, my lord. This honorable court has noted the.
My lord,
where is the order of reinstatement?
My lord, I'll file it along with the memo, my lord. I'll just. It has already come in the order sheet, my lord.
If something is, we will not pass an order. Please. However, if there is some delay in you giving effect to the order, you just pay that and close.
Lord, even I'll submit, my lord. I have produced the order of the learned single judge. There is interim order was never extended, my lord. I have produced the order sheet. Interim order was never, irrespective of that, my lord, we have taken back them to service. Even if there was no any interim order, we have taken.
Things have come to an end.
It has come to an end, my lord.
Taking note that the complainant has been reinstated. In terms of the interim order passed, proceedings are dropped.
Please.
Any contentions, if any of the complainant, are kept open for appropriate proceedings if a complainant is so advised.
Please, my lord.
Respondent 1 and 3 served, my lord. I will take notice for respondent 1 and 3, my lord, in this matter.
GA accepts notice for respondent 1 and 3.
Great.
Hitesh Padilla,
I appear for the complainant.
Yes.
Notice is not served, ma'am.
You have to reissue notice.
Please, ma'am.
Reissue notice to the accused.
Obliged.
Yes.
Till number 4, Kulappa Heru,
Lord, the notice to the fourth respondent has already been served by regular process. Lord, may hold the notice service.
Endorsement, postal endorsement. Postal endorsement. Delivery. You have the date. In light of the postal tracking report, which indicates delivery of the notice, service to R4 is held sufficient. Office to show the name of R4 as served in the cause list. Relist the matter.
Filed a memo for holding it sufficient.
Huh?
Memo I have filed.
No, we have relist the matter. Yes.
till number 5,
Lord,
Prashant V. Vajantri,
My lord, this is a regular bench matter.
First week of March.
My lord, the consideration of interim prayer, my lord, in this case. My lord.
What?
My lord,
Deputation. Huh?
I for early hearing mele it, my lord. The Sangati you matter refer ಮಾಡಿದ್ರಿ, my lord. HM Sangati versus register matter.
What is the matter?
My lord, this is the matter discharge, my lord. I am the on the case order mele appeal bandit, my lord.
Let us see. You have to hear it.
Yes, my lord. Short date, Monday. Monday, my lord.
6th of March.
Please.
till number 6, Vishal Pratap Singh,
This requires hearing. Let us see.
I was not served the copy of those report last occasion, my lords. Your lordship has directed registry to give me the entire proceedings that has happened before the trial court.
Huh? Just to find out in the branch.
I'll do that. Kindly 2 weeks time, my lords.
List after 2 weeks.
I'm grateful to your lordship.
till number 7, Patil Shantabai,
Claimant's appeal for enhancement, my lord. It's an injury case, my lord. R1 may kindly dispense, my lord. R2 company appeal is pending.
that is available.
As per the memo filed by learned counsel for the appellant, the notice to respondent number 1 is dispensed with at the risk of the appellant. List this matter along with MFA number so and so.
Much obliged.
Respondent number 2 ga. Innondರಲ್ಲಿ ಅವರಿದ್ದಾರಾ?
Yes, ma'am.
It is submitted that in the connected matter, learned counsel Srimati Preeti Patil has appeared for respondent number 2. Hence, the name of learned counsel Srimati Preeti Patil be shown in the process for respondent number 2.
Much obliged.
till number 8, Mahantesh Patil,
My lord, it is a contempt petition. Reinitiating of workman, my lord. Interim order is given by single bench.
On the mic, on the mic. Mic on mic.
Lord, this contempt petition for reinitiating of complaint of workman.
What is the direction now?
My lord, annexer.
The direction.
Annexer C, my lord.
Page?
Page 35.
They have not reinstated.
Yes, my lord.
Who is the employer? Respondent number?
Respondent number 1, Shivappa.
Emergent notice to respondent number 1 to 3. GA is directed to accept notice for the fourth respondent. Relist the matter on.
Number 9, Nagara.
I appeared for the appellant's counsel.
Yes.
It's against an interim order. Kindly see page 16, the order of the learned single judge, my lord. (16A), it is numbered as 16A, my lord. The order starts from there. The appellant, a cooperative sugar factory, is the borrower from respondent number 4, and there is a huge amount due. There is no dispute about that. The situation has led to such a stage that the possibility of the appellant repaying it in any viable installments is not there. Therefore, now the crushing is going on. It will go on up to first week of April, first week or second week of April. I made a submission that as far as this crushing season is concerned, except the payment of the workers and the running day-to-day running expenses, everything, farmers' payment, all the remaining amount will be paid to the bank. Thereafter, the only option is for taking out a proposal for leasing out the factory with this liability, and in whatever way it could be settled. Learned single judge accepts that, saying that appears to be the only way. Kindly see para 16B last.
Now we could do one thing. Now this is your proposal is essentially the matters between you and the fourth respondent. So
Please,
you serve the counsel. We'll have it on Monday. Let us see.
Please, your lordship may kindly have it on Tuesday, my lord. All that I am asking in the appeal is to not to take any steps so as to bring down the crushing to a halt, which would not be in the interest of the appellant or the respondent number 4. It's only that portion, last sentence in 16C.
Let us see. The sugarcane juice is no more sweet.
It's no more sweet, and the only way is to lease out the factory. It will not be possible to do it in another way. Kindly see page 16C.
We'll have it on. We'll have it on Monday. You serve. Let us see.
Please, my lord,
Tuesday.
your lordship, kindly see the sentence, last sentence in 16C, page 16C. However, this will not come in the way of respondent number 4 taking out proceedings under section 14 of the Act, but the same shall be subject to outcome. Only thing is, there is a possibility of crushing being interrupted.
You serve on the counsel who appears in the writ proceedings.
Please, my lord, your lordship. Monday I have some difficulty, my lord. You kindly have it on Tuesday.
Yes.
Only thing is, till Tuesday, let them not stop the crushing, which will not be in the interest of any one of them.
Let us see on Tuesday. GA accepts notice for the first respondent. Appellants are permitted to serve counsel who appeared for the respondents 2 to 4 in the writ proceedings. Relist the matter on Tuesday. Yes.
Consideration of interim prayer.
Bill number 10. In the
Yes.
Lord, serial number 10, my lords.
Number 10.
My lord, in this case, one more writ appeal is connected, my lord. It is not posted. 2,149 of 2000.
Please, my lord. Sir, there were two writ appeals.
Only one has been posted, my lord.
List along with the writ appeal number so and so.
Please.
When do you want it?
My lord, Monday or Tuesday, now matter is covered, my lord. Uma Devi's judgment after taking 10 years of continuous service, now they cannot rely on Uma Devi and say that you are not entitled for regularization. Latest judgment of the Honorable Apex Court. Here, my lord, there was a direction to regularize. They say that in between breaks were there. For that purpose, the regularization cannot be done.
Relist on 27th.
Please, my lord.
My lords, one submission, my lords, in this matter.
Yes.
My lords, it is posted for hearing before charge, but in the writ appeal that was listed today, my lords, interim order was granted, my lords, and matter was admitted. That day, on the day, my lords, when it was connected, my lords, this matter was already listed for hearing before charge. Thereafter, we filed writ appeals. In the writ appeal, there is already an order admitting and granting stay. So, in view of that, my lords, it has to be taken up for final hearing, including writ appeal along with WP number 200149. If I may just seek, my lords, except Monday, Tuesday, any other date, my lords, we are ready in the matter.
27th.
Relist the matter March 1st week. 6th of March.
Please, my lords. Along with the WP number.
Along with WA so and so.
Grateful.
Number 12. AM Khate.
Next to appear for the appellate. Appeared, and they took a contention that there is already a family partition based upon some ROR entries, but there was no family partition by meets and months, nor there was any document to that effect. The revenue entries were changed only to save the property from the ceiling limits. They are to be affected under the Land Reforms Act. The father of the plaintiffs was the only last male member in the family. Thereafter, the present appellants and defendant number 3 and 4, they are the daughters. Defendant number 1 and 2, they are the wives, my lord. Yes. Now, defendant number 1 was the first wife, she is also no more. Now, the appellants and defendants 3
All the
and
lands
4.
are acquired.
Please, my lord.
All the lands are acquired, is it?
All the lands are acquired, my lord. And now, after acquisition, the lands held by Baswaraj, his sister Sharanamma, and defendant number 1, my lord, they have been mutated on the name of defendant number 2 and 3. And now they are individually claiming the compensation of those lands, my lord. By taking undue advantage of the ROR entries, a succession mutation could have been sanctioned on the name of all the family members, but without bringing to the knowledge of the appellant plaintiffs herein, my lord.
But already there is a decree against you.
Please, my lord.
Already a suit which has been filed is dismissed.
No, my lord, there was no any suit.
Partition suit is dismissed.
Yes. Partition suit, it was for the first time suit was filed after death of Baswaraj.
Correct.
Yes, my lord. Now, if the partition was taken place during the life of Baswaraj, my lord, by respectful submission, with defendants 1 and 2 who are the wives, they are not entitled to have any independent share along with the husband, my lord. But the ROR entries, they have been shown on the name of both the defendants 1 and 2. Defendant number 2 was given some 12 acres of land. Defendant number 1 was given about 24 acres of land. Likewise, the ROR entries were shown, my lord. But in fact, there was no partition affected. Only to show the properties from the ceiling limits, my lord. That was a family arrangement which was made. Later on, all the properties have been acquired. Therefore, my humble submission, my lord, the Honorable Trial Court has not.
Adjourned counsel appearing for the appellant. The plaintiff who suffered the dismissal of the decree in a suit for partition is before this court, stating that the money, stating that the compensation in respect of the acquired
joint family properties are being released to the defendants, and if such amount is released, it may be difficult for the appellant to difficult to recover the same in case he succeeds in the appeal.
Please.
In that view of the matter, the release of the amount,
Defendant number 2 and 3, my lord. By the special land acquisition officer, Karanja project,
the amount by
which I have mentioned in my application, my lord.
respond number 2 and 3, na?
2 and 3, my lord.
Respond number 2 and 3 in favor of
Respond number, they get disburse the amount from land acquisition office. 2 and 3, my lord, they themselves get disbursed the amount. Karanja project is the office which has acquired the lands. Yes.
respond number 1 to 4.
2 and 3, my lord.
In the name of respond, in the
One
name
is
of
no
the
more.
Plaintiffs. Is in the name of the in the name of the defendants.
Yes.
Is stayed till next date of hearing. Till the appearance and
Temporary injunction or not stay, I have sought for temporary injunction.
then
I have sought for temporary injunction. Please.
is stayed, is restrained. Payment is restrained till the appearance of the defendants in this appeal.
Please.
Issue notice.
Much.
Yes.
Number 30, Basavaraj Verma.
I'm appearing for the appellant, my lord. Wife's appeal, my lord. The present appeal is filed against the order of decree of resolution of the marriage between the respondent number 1, appellant and respondent, my lord. The husband has filed the dissolution of marriage on the ground of desertion, my lord. Kindly see the cost title. They are living in the same home, and in the evidence it is elicited they are living in the same home. There is no desertion. I have contested the matter. I have filed a written statement where I did not go my native place, my parental house, because it is in Andhra. And there is only one paragraph order. There is no order on the prayer of the husband. He is seeking on cruelty and desertion. Kindly see the paragraph number 16 of the order. It is just simply said that they both are no faith on each other. They did not have a make-up mind that they should continue to be husband and wife. Marriage was dissolved. Paragraph number 16, impugned judgment page number 11, Malad. Both husband and wife have no faith in each other. This is an on account of many complaining the situation. Relatives of the both sides virtually have come to conclusion that two spouses cannot be changed so better. Section that is order is against the section 13 of the.
ನೀವೇ ಹಂಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಿರಲ್ಲ ಇಲ್ಲೆಲ್ಲ ಅಪೀಲ್ಸ್ ನಲ್ಲಿ irretrievable breakdown, marriage is broken on all grounds. ಮಾಡ್ದ
ಅಲ್ಲ ಆಫ್ ದ ರೆಕಾರ್ಡ್ ಅಂದ್ರೆ ಕರೆಕ್ಟ್ ಆರ್ಡರ್ ಇದು ಒಂದು ರೀತಿಲಿ ಆಫ್ ದ ರೆಕಾರ್ಡ್.
There shall be an interim order as prayed till next date of hearing. So notice.
ಅಲ್ಲ ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಂದ್ರೆ ನಮಗೆ ನೆನಪು ಹೋತಂದ್ರೆ ಸ್ವಾಮಿ ಮತ್ತೆ ಡಿಸ್ಕಂಟಿನ್ಯೂ
The respondent is restrained from contracting any second marriage.
Please. Much.
A small submission, serial number 6. The session court where the inquiry of juvenility had been conducted has retained the original school admission register of that school. The school authorities are continuously calling me to get the certificate. Let there be direction to return those admission register, original documents of the school. Admission register they have retained.
in the report. Section 4.
Original है. Original है. Number 6.
Register. You file an application.
No, he has not filed
Application
any.
for return.
To return, I'll file an application.
Yes, you are from a school.
Alan, that document is there with the trial court. Application.
It's marked. Marked. Then how can it will give?
What is that report?
Report is to the effect.
Report is against. Report says he was not below 18 years. But of course, we'll look into that.
You file an application.
Application before this court, my lords. I'll do that.
Now we have summoned it, isn't it? We have summoned the report.
Yes, yes. That report, my lords, bandi diya.
The report along with documents have been called here.
Yes, it has been called, but I'm not sure, my lords, whether that report is part of the record now here.
You verify whether
Verify
that
it.
register is part of the
File it.
record or not. If it is part of the record, you file an application
With
for return
consent.
of the registers to the concerned school.
I'll
So
do
that
that.
you can get the
Yes.
copy or whatever.
I'll do that. I'm very grateful.
ಎರಡು ವಿಡ್ರಾವಲ್ ಇದ್ದು ರೀ ಕರೆಕ್ಟ್ ಪ್ರಕಾರ ಎಲ್ಲ ಮಂಡೆ ಅದೆಲ್ಲ ನೋಡಕ್ಕೆ ಇದೆ ಅಂತ ಹೇಳ್ಬಿಡು
11:30 ಆಯ್ತು ಸರ್ 11:30ಗೆ ಸಿಂಗಲ್
My lords, kindly, serial number 15, my lord. Next. There is no interim order, my lord, and kindly have it next week.
At request,
My lord, serial number 14.
list the matter in the first week of March.
My lord, serial
Serial
number
number
14. 14, my lord. Next.
Have you informed the other side?
Yes, my lord. Yes, ma'am.
Yes.
At
Serial
request.
number 19, my lord. I
Just
appear for
one,
the petitioner.
just 1 minute. Relist the matter in the second week of March.
Your Lordship, serial number 6, Your Lordship.
Serial number
Kindly
19
have it
was-
next week.
Just wait, video conference last, please wait.
Please.
Serial number,
Serial
serial number
6, Your
12,
Lordship.
my
Serial number 6.
6.
Please, Lordship. Kindly have it next week.
At request, list the matter 6. You must inform the other side.
Please.
Week after next.
Grateful.
My lord, 17, my lord.
Uh,
That side inform, my lord. Short accommodation.
At request,
17, my lord.
relist the matter week after next.
serial
Please.
number 12, my lord. Serial number 12.
Yes.
I am for respondent, my complaint informed me.
Yes.
I am for respondent, my lord. Kindly week's time may be there.
At request, inform the other side.
Here is says interim order may be extended.
List the matter week after next. Interim order earlier granted is extended till the next date.
Your Lordship, on submission. In
Serial
serial
13 also, my lord. Serial number 13. I am for respondent.
At request made on behalf of the respondent.
Appellant counsel is here, my lord. I am for.
Who is disposing of this? 13, no? Huh? At request 13, at request list the matter week after next.
Your Lordship, in serial number 6, there is interim order. It may kindly be extended.
6. Interim order in operation is extended till the next week.
Grateful.
Yes.
Not
When
serial
speak
number
through
19. I appear for the petitioner, my lord. 1 week time may come.
Yes, inform the other side.
Yes, I will inform. Interim order may be extended, my lord.
At request, list the matter week after next. Interim order earlier granted is extended till the next date.
Please.
Serial number 1, Vinayak Apte.
Week's time granted to take necessary steps.
Number 2,
They are disposed into those things.
number 2, KM Khate.
Next to appear for petitioner. Yes, my lord, respondents 2 and 3, they are just formal parties to the present writ petition. The contest is only respondent number 1 plaintiff. my lord. May I seek for dispensation of notice for the respondent number 2 and 3, my lord.
R2 and R3 is dispensed with at the risk of the petitioner.
Please, my lord.
In light of the memo filed and submission that the said respondents are not the contesting respondents insofar as the present writ petition.
Please.
Relist the matter.
Matter, my lord, the present petitioner is a defendant number 3. And he is the purchaser of one of the suitable properties. And he filed the return statement, my lord. After filing return statement, he wanted to amend the return. For the purpose of amendment of that return statement, the application came to be filed by the present petitioner.
Suit for what is the
Suit is
proposed
for
amendment?
partition and separate possession.
You are the
I am the purchaser of the property, my lord. Defendant number 3. One of the property I have purchased. And after filing the return statement, my lord.
what is the proposed amendment?
Yes, my lord. Proposed amendment, my lord, annexure. Annexure G, my lord, page 46.
Read.
Yes, ma'am. The amendment sought was that the suit of the plaintiff is barred by limitation, that the suit of the plaintiff is not maintainable without challenging the judgment and decree of Udgir Court in RCS number 38/1999, dated 17/1/1999 that the suit of the plaintiff is not maintainable without impleading state as a necessary party, as some of the land in the suit lands has been acquired by the government and hence the state has got interest in the suit property. And in the absence of the state, a suit is not maintainable for non-joint of the necessary party. That the suit of the plaintiff is not maintainable without excluding the land acquired by the government. That the suit of the plaintiff is not maintainable in view of amendment to Hindu Succession Act, since already a right has been discussed and decided in RCS number 38/1999 by the Honorable Udgir Court, as partition is confirmed by civil court in RCS number 38/1999. That the suit of the plaintiff is not maintainable without showing specific boundaries of the house plot bearing Gram Panchayat number 32 in survey number 141A of the suit schedule B.
My lord, he is a purchaser pendent lite. My lord, after filing of the suit, he has purchased the property. Therefore, formally he is brought on record. At the inception, my lord, he has denied all the contention of the plaint. Whatever he is bound by is, my lord, is the defense taken by defendant number 1 and 2, who are the sellers of
The purchasers
pendent lite.
pending the suit.
Yes. Therefore, now, my lord, based on an application seeking amendment, all these contentions.
You will reserve liberty for your vendor to.
The only defense could be taken by him.
What happened here, my lord? Even with regard to my right to the property, I was brought on record later on by way of amendment, my lord. That is annexure E, be kindly peruse.
Correct. Now, if the sale deed is during the pendency of the suit, you can dispose it of reserving liberty for your vendor to raise if so advised.
Please.
For vendor.
No. So far as amendment, my lord, even if such kind of amendment is allowed, ultimately burden is on the person who seeks amendment, my lord. So he can very well seek.
You are a pendant, you are a list pendants purchaser. You raise it to your vendor.
No, my lord. 3/5/2014 is the document, and suit is filed.
On 23/4/2014.
Please, my lord.
23/4/2014.
No, my lord. Suit is filed.
Page 12.
Yes, my lord.
23/4/2014.
Please, please.
So we'll reserve liberty,
please,
for your vendor. When is your sale date?
Please, Lord.
Sale deed date.
Sale deed 3/5/2014, my lord.
3/5.
In page number 38, when the plaintiff files amendment application, she sought an amendment to para 4 of her plaint, and thereby, my lord, bearing document number 2073 of 14 dated 3/5/14.
Yes, yes.
Sub-Registrar Office Udgir. So thereafter, I was brought on record, my lord.
ನಿಮ್ಮ ಅಮೆಂಡ್ಮೆಂಟ್ ನೋಡಿ ಜಡ್ಜಿಗೆ ಸುಸ್ತಾಯ್ತು.
Please.
The defendant number 3, who stated to be the purchaser from.
Defendant number 2 and 3, my lord.
Who stated to be the purchaser from defendant number 2.
Defendant number 2.
Defendant number 2.
Has filed the present petition.
Yes.
Calling in question correctness of the order passed on IA 19 filed under order 6 rule 17 read with section 151 of CPC, whereby application of defendant number 3 to amend the written statement,
please,
came to be rejected.
Page 46, annexure G is my amendment application.
The trial court has observed that the proposed amendment is not required for adjudication of the real controversy. The next suit for partition and separate possession has been filed by the plaintiffs, and the defendant number 3 stated to have purchased the property which is a part of the suit schedule from defendant number 2. Full stop. No doubt, next, no doubt, plaint was amended and defendant number 3 was
brought on the court.
impleaded as an additional party in light of the purchase.
Order dated
In light of the purchase. Full stop. Next.
8/11/2019.
The defendant number 3, after having filed the written statement, had sought to raise various contentions by way of amendment. The next, the proposed amendment reads as follows, page 46.
It is also at the stage of evidence. I had led in my evidence.
At para 1 to 1A to H. Full stop. Next, it is admitted that the application was filed at the stage of evidence. Next.
Before cross-examination of PW1.
After the evidence was trial.
Seal number 5, Muhammad Abdul Qayyum.
This case, writ petition is challenging this. Similar writ is filed in another case also. It's pending.
Your Lordship, in this matter, Your Lordship had appointed me as amicus curiae in this matter to assist on 2 points, Your Lordship. Firstly, whether the in case where subject matter is or issue is involved in is challenged before the apex court and it is pending, whether the Your Lordship has to wait for the ultimate result of that particular case, or whether Your Lordship might continue the case. Your Lordship, there is one judgment of the Honorable Apex Court, Your Lordship, if I may kindly pass on. This is a tedious matter, Your Lordship, where the interest need to, Your Lordship, in the fourth page, Your Lordship,
Correct. So we can go ahead there.
page number 4, Your Lordship, it says about the practice and procedure, Your Lordship, if I may read. High courts not deciding cases.
Page?
Lordship, the fourth page, Your Lordship. Page 71, Your Lordship. At the corner. 71. If I may read.
Which para? 35 or 36 or 37?
It is in the para 35, Your Lordship.
Read para 35.
Please, Lordship, if I may read. It is at page number 96, Your Lordship.
Yes.
We are seeing before us judgments and orders by the High Courts not deciding cases on the ground that the leading judgment of this court on this subject is either referred to the larger bench or a review petition relating thereto is pending. We have also come across examples of the High Courts refusing differences to judgments of this court on the score that a later coordinate bench has doubted its correctness. In this regard, we lay down the position in law. We make it absolutely clear that the High Courts will proceed to decide matters on the basis of the law as it stands. It is not open unless specifically directed by this court to await an outcome of a reference or a review petition, as the case may be. It is also not open to the High Court to refuse to follow a judgment by stating that it has been doubted by later coordinate bench. In any case, when faced with conflicting judgments by the benches of equal strength of this court, it is the earlier one which is to be followed by the High Court, as held by the 5-judge benches, National Insurance Company versus Pranay City. Your Lordship, the Honorable Apex Court is very clear with regard to that, Your Lordship, saying that whatever the law is prevailing at that point of the time, it can be, the High Courts can move forward with that.
So in this case, what is the law as on date now regarding TDS?
Please, Lordship, if I may pass on the written submissions with regard to that. Your Lordship, the other High Courts have said that, Your Lordship, the TDS cannot be deducted on the interest of the compensation granted by the courts, Your Lordship.
Now, in the present, before going to your note, in the present case, what are the facts?
Your Lordship,
They have deducted?
no, already they have deducted, Your Lordship.
They've deducted TDS.
Please, Lordship.
Now that has been challenged.
Please, Lordship.
Stating that you don't have to deduct.
Please, Lordship.
That's their contention.
Please.
So what is the law as on date?
Your Lordship, the other High Courts, Your Lordship,
Section
in
140.
particular cases.
Now in the present case, TDS has already been deducted.
Even if it is deducted, Your Lordship, they can please, Lordship.
No, but here they have deducted this.
Please, Lordship, they are deducted.
Page. TDS has been deducted.
42,000 is deducted out of 10. 3,61,000 interest was there. Para 2 of the memo of writ petition.
Page 27.
Page 27 is the order of.
27 you read. Let us see what that order. That is the order, isn't it?
Yeah.
Read that order.
Missing.
You have a copy? Page 27.
Is missing. I have got that. Page 27, Your Lordship. It is fifth paragraph.
No, read the entirety. Let's.
Entire
Order on submission dated 29/9/2018.
advocate for decree holder has made submission that on stating that the present case is filed for recovery of compensation amount awarded in MBC 257 bar 2005 in respect of death of son of petitioner number 2 in a motor accident, that the judgment debtor insurance company has deposited a sum of rupees 9,56,974 on 27th July 2014 and rupees 44,872 on 27th March 2015 towards satisfaction of the award passed in MFA number 30606 bar 2008 and 31083 bar 2010 before the Honorable High Court, but judgment debtor has deducted TDS of rupees 40,770 on dated 28/7/2014 and rupees 2,028 on 19th March 2015, totally 42,798, which is wrong and incorrect as per law. Neither the compensation amount or the interest earned on the compensation amount comes under the definition of income as per Income Tax Act. Therefore, the deduction of tax of rupees 42,798 on compensation amount is illegal and against the provisions of law. For these reasons, prayed to direct the judgment debtor to pay 42,792, which is deducted towards tax along with interest at 12%. In response to the said submission, the judgment debtor insurance company has produced Form 16A 2 in number. The counsel for judgment debtor 2 filed a memo on 3/12/18 stating that as per section 144J of Income Tax Act, the judgment debtor company has deducted the tax on the interest earned as the same is taxable. Heard both sides and perused the records. The counsel for may Your Lordship show the Lordship the provisions of section 194.
No, we'll finish and then we'll go to the problem.
The counsel for judgment decree holder has argued as per the submission dated so and so and relied on two decisions. The decision of Honorable High Court of Madras in the case of Managing Director Tamil Nadu State Transport Corporation Limited versus Chinnadurai, and decision of Honorable High Court of Punjab and Haryana in the case of New India Assurance Company versus Savitri Devi and others, wherein the Honorable Courts have held that since the MV Act is a social welfare registration, the same will prevail over the provisions of Income Tax Act 1961 and the interest payable on the compensation is not taxable. It is pertinent to note that as per the amendment of section 194A, subsection 9 is substituted with 9A with effect from 1/6/2015, which contemplates that the interest exceeding rupees 50,000 in respect of compensation awarded under MV Act is taxable income. The said amendment came into force with effect from 1/6/2015. Therefore, it is applicable prospectively. On perusal of form number 16A produced by the judgment debtor number 2, and as per the submissions, the award amount was deposited on 28/7/2014 and 27/3/2015, and the TDS was deducted for the years from 1/7/2014 to 30th September 2014. In view of the amendment of section 194A 39A of Income Tax Act, as on the said date, the interest on the compensation was not a taxable income. Therefore, the judgment debtor had no legal sanctity to deduct the TDS in respect of interest on this compensation amount. Therefore, as rightly submitted by the advocate for decree holder, the said TDS deduction is illegal. Therefore, judgment debtor number 2 is liable to pay the TDS deducted to the decree holder along with the prevailing rate of interest paid by the Income Tax Department in the case of refund of tax. Accordingly, submission dated so and so is disposed of for payment by 2/2/2019.
So what is the amendment made? Income Tax Act.
Amendment made in income tax is 194A, clause 9A is on the second page. 9A. Income exceeding, interest exceeding 50,000 is liable to be taxed. Earlier to this also there was TDS on income on the interest portion of the compensation. There was no limit of 50,000. Now 50,000 is exempted by this amendment. Up to 50,000 tax need not be deducted. That's why earlier judgment of the Honorable High Court by Justice S.A. Nazir.
No, 50,000, the interest, if the interest amount is above 50,000,
that is liable to be taxed.
then the interest on such,
on exceeding the 50,000 amount has to be, TDS has to be deducted. That is done.
On the interest, if it exceeds.
Only interest portion, not on the compensation. Interest portion only. Justice Nazir of this court, Your Lordship, a judgment I have quoted in para 6 of memo of appeal.
Your Lordship, the petitioner, they have relied upon this judgment of this honorable court, where it says that the claimants can claim refund of the aforesaid amount from the competent authority. Your Lordship, they have given
after deducting the TDS, the company issued form number 16A. Basing on that, they can claim refund of the amount.
No, that is there, but now this amendment was made in which year?
2015.
Now the this interest was paid in which year now?
Interest was paid before 15, before amendment.
Before amendment.
But the judgment of our High Court before amendment is there.
No. In the present facts of the present case,
yeah,
now the amendment was.
It was later, Your Lordship. The amendment came to be existence later. So
on
the year 2015.
Amendment 1/6/2015.
1/6/2015.
So it is a prospective in nature.
My
So
submission is, Your Lordship, prior to this amendment, there was deduction of tax, but 50,000 was not there. That leap exceeding 50,000, that clause was not there. That is added by this amendment. Because of that, our High Court judgment earlier is earlier to this.
Just 194.
194A. Subclause 9.
Your Lordship, basically interest is not an income but an extension of a compensation itself, Your Lordship. So, Your Lordship, which is meant to provide just relief to the victims and their families.
Just 1 minute. Let us see what 194 is. 194A provides for an obligation to deduct tax at source. 194A.
Yeah.
Under 194A1, any person who is responsible for paying by way of interest other than income has an obligation to deduct tax. 194A
3.
Subclause 9.
9.
Originally, the clause before 2015 was to such income credited or paid by way of interest on compensation amount awarded by Motor Accident Claims Tribunal, where the amount of such income, or as the case may be, the aggregate of amounts of such income credited or paid during the financial year does not exceed 50,000 rupees. So, in terms of the section prior to 2015, if the interest amount did not exceed 50,000, there was no obligation to deduct. Prior to 2015, after 2015, the amendment is effected on 1/6/2015. Under the present clause, nothing in subsection 1 shall apply to such income credited by way of interest on compensation amount awarded by the Motor Claims Tribunal. So there is no tax,
Your Lordship,
no obligation. That is the amendment.
Your Lordship, the judgments of our judgment.
So forget about the judgment. Look at the provision. Amendment is made. Amendment has now exempted.
That exemption prior to 2015 was also up to 50,000.
No.
Above 50,000.
No. Look at the amendment.
This
After 2015, they have removed that 50,000 limit.
even Kerala High Court.
No, you look at the provision. You look at the provision. Forget about the judgment. Look at the provision. Nine you see, and look at the footnote.
This 194A, clause 1, clause 2. Clause 2 is a proviso. Provision of subsection 1 shall not apply. Clause 1 says TDS to be deducted. Clause 2 shall not apply. Under that, up to 50,000 was there, this clause.
That was earlier.
Earlier.
Now,
Earlier.
look at the present clause. Read the present clause.
Present clause, some changes with regard to during the financial year.
No, you see the.
Not exceeding 50,000. Earlier it was 50,000.
Correct. Now they have removed that limit.
No, they added during the financial year. This is actually to be read as a proviso under 194. Class 3. 194 class 3. Class 3 is proviso, exemption. Up to 50,000 is exemption. Earlier it was exemption without considering any financial year. Class 3 reads, your lordship.
No. Now class 2 has been omitted. Class 3 provides that nothing in subclause 1 shall apply. Nothing in subclause 1 shall apply. Now you go to 9. Income credited by way of interest on compensation. So now there is no obligation to deduct tax.
Please, Your Lordship.
That is a position.
There is no obligation to deduct the taxation. Please.
In terms of 194.
Please.
May I draw your lordship's attention to 194A clause 1, then under clause 1 also provided is there. Clause 3, the provisions of subsection 1 shall not apply.
Shall not apply. So
means
the obligation to deduct tax is under 194A1.
1.
Now that will not apply.
Will not apply. If,
Where? Now what is the clause?
That
to such income credited by way of interest on compensation amount awarded by motor accident claims tribunal. So if interest
prior to amendment.
No,
prior to amendment.
Amendment has come into force from 1/6/2015. After 1/6/2015, if you were to pay interest on compensation amount, no tax will be.
No tax.
That's what it says.
Please.
Your lordship.
What are the judgments?
Prior to the amendment also. That clause may also be read.
No, I'll consider. Now, what are the judgments after the amendment? You have anything you point out?
Your Lordship, there are judgments of the other Honorable High Courts, Your Lordship, which says that the interest cannot be treated as income, Your Lordship. So the TDS need not be deducted on the.
You're correct, but now the provision itself is clear.
Please, provision is clear.
Itself,
Please.
3 Roman 9.
So in this matter, Your Lordship, they are already deducted. It can be refunded back to the claimants.
That is the position. Because
Please.
under 9, even without entering into that, it says nothing in 1 shall apply to such income credited by way of interest on compensation amount awarded by the motor
Please,
accident claims.
Please.
Footnote. Now just take me through your note. Let us see. Yes. Yes. Up to 50,000. Correct. Yes. Now that has been removed now. After 1/6/2015. No. Just check. That has been removed.
Here it is 50,000. Now 9A you see. Where is 9A?
Clause 9.
Yeah, I know.
Old 9 and 9A has been substituted. Roman 9 is a substitutes the old provision.
Substitution is from clause 8 onwards.
Correct.
8, 9A, 9A, 10, 9 up to 9A is substituted.
What is the new clause?
The new clause says exceeding 50,000 tax is to be deducted.
No. You're wrong, reading it wrongly. The substituted clause at Roman 9 now says to such income credited by way of interest on compensation amount awarded by the motor accident claims tribunal. There is no 50,000, nothing. Now, what is your note? What judgment you have?
Karnataka High Court judgment.
No, that is prior to amendment.
Prior to amendment. There also.
No, that's prior to amendment.
Prior to amendment, High Court said justified. This is after amendment.
What is
Nothing, Your Lordship.
What is your note now?
Your Lordship, it is very clear, Your Lordship. Various High Courts have said that the TDS cannot be deducted, Your Lordship, and
similar issue is pending before.
now they are placing the submissions before this Honorable Court, saying that there are several matters which have been combined, and the matter is pending before the Honorable Apex Court. And Your Lordship, on the second point which Your Lordship have asked me to assist is whether the court need to wait with regard to outcome. Please, Lordship. So the act itself is very clear, Lordship, and the TDS cannot be deducted in this matter is what. Now, since they are already deducted, Lordship, it can be refunded back to the claimants.
So what is the procedure now that you are following?
Deducting tax exceeding 50,000.
Mr. Reddy. Motor vehicles case, when the insurance company is paying the compensation, TDS you are deducting on the interest or no? What is the practice that you are following?
One judgment I came across.
What is the practice that you are following?
Companies are deducting
So
about.
when the insurance company is paying,
my lord.
you pay the compensation amount, including the interest.
Yes, my lord. Whatever accrued on the award amount.
Now the TDS is being deducted or not? What is the procedure being followed?
Where PAN card number is not given, 20% is deducted. When PAN card is given, 10% is deducted. That is the practice in all the companies. In all the companies.
ನಿಮ್ಮ manager ಸುಮ್ಮನೆ telephonically ಕೇಳಿ. There are two things.
Yes. One.
When the compensation is paid and there is a component of interest on the compensation. Under 194 capital A,
I will give him 194 capital A.
194 capital A,
class 3,
within bracket 3, Roman 9.
Roman 9.
After amendment from 1/6/2015.
1/6/2003.
15.
According to my reading,
yes,
no
deduction.
No TDS on interest.
Yes. May I submit one thing? I worked in an insurance company in Hyderabad 15 years. Prior to 15, I was in Hyderabad. There was income tax notice to the insurance companies how much tax interest you have paid during the financial years past 3-4 years. Then Assistant Commissioner issued notice to us. They recovered 60 lakhs from the insurance companies for not deducting TDS. Then onward, this practice is there even prior to 2015 as law was prevailing. Your Lordship may have it next week. I'll just clarify once more. Or 2 days later.
Next week I'll be in Bangalore. Now
there is one more.
The plain subsection is clear. It says there's no TDS. Nothing in subsection.
Kerala High Court judgment is also there. Your Lordship. Interpreting same thing.
1/6/2015.
Yeah. 1/6/2015 prior to.
After which on compensation there is no liability to deduct TDS on interest.
One more. May I read once again, Your Lordship.
Yes, yes.
9A.
Yes.
After the amendment.
No. After amendment, no 9A is there.
9A is there.
After amendment.
After amendment, 9A is there.
Correct.
9A is there after amendment.
Yes. Read.
Here it says to such income paid by way of interest on the compensation amount awarded by the Motor Accident Claims Tribunal, where the amount of such income, or as the case may be, the aggregate of the amounts of such income paid during the financial year does not exceed 50,000. This is exemption. Up to 50,000 exemption is there. Above 50,000.
Then what is 9 then?
9 earlier in the footnote. To such income credited or paid by way of interest on the compensation amount awarded by the administrative, where the amount of such income, or as the case may be, the aggregate of the amount of such income credited or paid during the financial year does not exceed 50,000 rupees.
Now there is a distinction.
Oh shit.
No, just 1 minute. There's a distinction between 9 and 9A. 9A refers to income paid by way of interest on compensation amount. What is the difference between 9 and 9A? There appears to be some overlap.
Interest is considered as income. Compensation is not considered as income.
No, but what is the difference between 9 and 9A? There's an overlap in the language.
No, during the financial year.
No. You come to the amended Roman 9.
Amen.
To such income credited by way of interest on compensation amount awarded by the Motor Accidents Claims Tribunal. 9A is again repeating to such income paid by way of interest on compensation amount awarded by Motor Accident Claims Tribunal, where the amount of such income, or as the case may be, aggregate of amounts of such income paid during the financial year does not exceed 50,000.
Only wording.
ಅದು ಇನ್ನೊಂದು ಬುಕ್ ಚೆಕ್ ಮಾಡಿದ್ದೇನೆ ಪ್ರಿಂಟ್ ಏನಾದ್ರು ತೆಗೆದು ನೋಡೋಣ 194.
Such income credited is removed. Not much difference is there, Your Lordship.
No,
Yeah,
how
prior
there
to
is some
amendment.
During financial year does not exceed 50,000.
उसको exempt है about 50,000 income tax. ये क्या है? Difference क्या है? दो clause. Same है.
नहीं, ये दूसरा ना
New है. ये added है new one. ये bold है. 1 minute. Purchase का खाली. ये नहीं. Only 9 and 9A bifurcated by this amendment. 9 is separated. 9A.
But the language appears to be
Same is there. 9 and 9A, two bifurcated. Clause 9 you can read, Your Lordship.
correct. Clause 9 says to such income.
Credited is removed from that clause. Here it is credited. To such income credited by way of interest on the compensation amount awarded by the claims tribunal.
This is include new act.
New act. इसमें difference.
The word paid is there under 9A. Under 9 it says credited.
Credited or paid, both were there. This is differentiation is done. I don't know what is credited and paid.
Now under 9A 50,000. So if doesn't exceed 50,000, then you have to deduct.
Yeah.
That is understandable.
Under both circumstances, prior to 15, after 15.
No, just let us look at the present clause. Under Roman 9A, if you pay
Interest up to 50,000, no tax. TDS will not be deducted. That is exempted.
No, up to 50,000 you have to deduct.
Financial year does not.
This
Clause
is
3, just 1 minute. Clause 3
proviso.
Starts with
Provided
the provisions of subsection 1
do not apply.
shall not apply.
Yeah.
Now you come to
one says we have to deduct.
correct. So that means now you come to 9A. So the provision of 1 shall not apply if the interest that is paid does not exceed 50,000.
Yes. Exceeding 50,000, we have to tax.
Deduct.
We have to deduct.
That's all.
Even prior also, subsequent, after the amendment, same.
Then, correct. Then what happens to 9?
9 is credited, word added there, we are paid is added in this 9A. That's the difference I am seeing from old class. Old class credited is included in that.
So whether the word credited refers to interest in an FD, I don't know. Suppose you keep it in an FD, fixed deposit, and the interest goes on accumulating in the fixed deposit.
We don't keep, Your Lordship. This is only paid immediately. Insurance company is not keeping FDs.
Your Lordship, in this
It's only court does.
But then there is some difference between credited and paid.
credited is something, Your Lordship, where the companies credit or deposit the money to the bank accounts of the claimants, Your Lordship. Paid, Your Lordship.
Company does not deposit in bank accounts of the claimants. They deposit in the courts.
No,
Satisfaction is that.
The companies credit to the bank accounts of the courts, Your Lordship. Further, the said amount is dispersed to this claimants, Your Lordship. The dispersion amounts to the paid, Your Lordship.
No, I'll do one thing.
Please.
I'll have it on 27th at 2:30. Special order. Special order. After division bench,
Same है इधर credited and paid है words. Credited और paid है. Paid है. दो अलग करे बस.
Shall we have it on Thursday? Have you do your research and come.
Yes.
There is some point. It has implication on many matters. So now we have to find out the difference between the word credited
Paid.
under 9 and paid under 9A.
9.
I don't know what, maybe there is some accounting significance between credited and paid.
Much. There is one more writ petition before a single judge. That may also be clubbed with this. Same issue, same issue.
So let us see, we'll decide it here.
Much. No problem.
Case,
No problem.
in case there's somebody dealing with income tax, we can
27th means
find out.
Please, I'll
Find out some chartered accountant
Much.
or income tax practitioner.
Will.
What is the difference between
9
and 9A?
9.
Because in many matters this is being done. We'll clarify. Let us
Much. 27.
relist the matter on 27th. 27th.
Please,
After division bench, I'll take it.
please. Even your lordship, in the 2024, same matter came up before the Justice Arvind Kumar before the Supreme Court and your lordship, with another honorable judge, your lordship, and the Supreme Court, Apex Court, it referred the matter to this, asked the Union of India with regard to whether the TDS can be deducted on the interest component, your lordship. But there is no such development or submissions made by the subsequent by the Union of India with regard to that, your lordship. Now that has become incomplete with regard to that, and it has no development has taken place in that matter, your lordship.
Let us see.
In other, your lordship, other high courts are following the procedure with regard to this, your lordship, that the TDS cannot be deducted on the interest component because interest cannot become a part of income, your lordship. So when it cannot become a part of income, then the Income Tax Act will not come into picture, and
Correct. That may be one interpretation.
Please,
but now the provision itself,
provisions, please,
provision itself is clear. So it says interest on income paid by. So see, after 2015, if there's anything which has touched this aspect, let us see.
Please.
We'll let it on Thursday.
Right. Obliged.
Third, the amicus and counsel for the petitioner. The question as to whether TDS is required to be deducted as regards interest on compensation paid requires to be clarified in light of section 194 capital A sub rule 3 within bracket Roman 9 for further submissions of both sides. Relist the matter on Thursday. So now, as per the present practice, you are deducting once it exceeds 50,000.
50,000. There are also two rates are there applying. Where PAN card is given, 10% is deducted. When PAN card is not there for the claimants, they deduct 20%.
Your lordship,
As per income tax rules.
One more submission, your lordship. The interest is given to the claimants because of the delay which has caused, your lordship. Now there is that fault, or it cannot be relied on the claimants, your lordship, because they are seeking for compensation. If the compensation is paid to them, the proper compensation is paid to them at the starting point itself, they need not, your lordship.
The law of income
no,
tax.
because the procedure or the law itself is the.
Correct. One of the,
it takes its own time, your lordship.
One of the principles in tax is tax has no equity.
Please,
tax has no equity.
Equity, please.
So, if the provision says you have to, they have to. Otherwise, the consequences will be. So, examine, let us.
Yes.
But it will have implication on other matters. Let us see.
Please, Rosh.
Number 7, KM Ghate.
Lord, on submission, my lord. Lord, for respondent 4, our name Ambrish Surja is appearing, my lord. We don't have any instructions signed Wakalat, my lord. We don't have any instructions or Wakalat to appear on behalf of respondent 4, my lord. Kindly delete the name of Ambrish Surja for respondent 4, my lord.
But what is the matter?
Matter, my lord, regarding filing application under section 340 of,
No, they're going to engage somebody or he's going to find out.
My lord, by error, our name is appeared, my lord, as Ambrish Roja.
Who is R4? Let us see who's R.
initially all of them have engaged Mr. Hanumantraj Sindor.
No, who is R4?
R4 is, my lord, one of the plaintiff. Sujata.
So he has
We
no
don't-
instructions.
We don't have file also, my lord, we don't have instructions.
So that means now notice must go to R4.
Yes, ma'am.
You serve on the counsel appearing in the trial court also.
Mr. Hanumantraj Sindol is already on record.
Who?
Hanumantraj Sindol, my lord. Hanumantraj Sindol, who appears for respondents 1, 2, 3, 5 and 6.
Correct. 4.
All of they are the common plaintiffs before the.
Correct. But now for 4,
Please.
Either Sindol will have to file.
Yes.
Or
I am permitted to take out notice that Hanumantraj Sindol
yes,
for respondent number 4.
learned counsel so and so appearing on behalf of Amresh S. Roja submits that they have no instructions to appear for R4. Accordingly, office to strike out the name of learned counsel Amresh S. Roja shown as appearing for R4. Emergent notice to R4. The petitioner is permitted to serve. The petitioner is permitted to serve notice by way of hand summons on counsel for R4. Full stop. Petitioner is also full stop. Learned counsel for the petitioner submits that the co-plaintiffs are represented by Hanumantraya Sindol. Yes, full stop.
Who is already before this honorable court is appearing for the other.
Learned counsel Shri Hanumantraya Sindol, who appears for the co-plaintiffs, to obtain instructions whether he could appear for R4 by the next date.
Please.
He list week after next. Yes.
Obvious.
Yes.
My lord, the petitioners in an institution of Siddhartha Samati having property, earlier they have occupying the premises on the leasehold basis from the corporation. And there are several shops are there, my lord. Earlier, the respondent filed a suit, OS number 246/2004 for permanent injunction. Because he was a tenant under me, my lord, under supply. So a suit came to be decreed not to evict him, and any eviction must be in due process of law. Thereafter, my lord, there is a master plan implemented by the corporation. All connected shops, not including these, have been demolished by the corporation. Demolished. And the respondent has not raised a voice regarding or not put forth at least his grievance to the authorities or the persons who are demolishing it.
So why will they care about your injunction?
My lord?
Why will they care about your injunction?
Demolished.
Now
shops are there vacant, my lord.
Demolished.
So considering my sympathy, my ownership, he also requested, and he also requested if any constructions made shops, we'll give him one. We have passed the resolution, even that.
So
It
now
is
what
an exercise.
Correct. Now what has happened?
Now their disobedience they have found. And can this execution petition can be executable and hold me that I am order of the court has disabled me.
Let us have a look.
I have filed an application.
How is it
Page
called?
49, my lord.
Page
49.
As on date, there's nothing there.
No, nothing is there.
The demolition is by the authority.
Authorities.
Not
All,
by-
not one single, my lord. Entire road stretch.
Page.
Page, my application is my 47, my lord. I have filed an application.
No, what is the, let us have a look at the prayer in the execution petition. Now the execution petition was filed on 15/12/14.
Yes, ma'am.
Now when was the shops demolished?
Shops demolished.
Lord, may I submit? What my contention is that these shops are not demolished by the corporation. It is they themselves, my lord, have demolished. I resisted that. In spite of that, my lord, they have, my lord, some of the shops they have demolished. Therefore, I filed a, my lord, execution petition. Now, my lord, I have produced the document to show. Their case is that these shops are we have not demolished. It is demolished by the corporation for road vending. I have produced the document before the, my lord, executing court. By the endorsement of corporation itself, they say that this building, the premises is not coming under the widening of the road. We have not demolished the building. This is the endorsement given by the corporation. Now, what the trial court, my lord, in EP says that we cannot straight away reject this execution petition. Can you see paragraph 13 of the, my lord, impugned order?
Page?
Page number 61, I think, my lord. Paragraph 13, my lord, page number 61 of the impugned order by the executing court. May I permit it to read, my lord? That you will
Read from page 59.
Yes, my lord.
Reasons.
Reasons. ತೀರ್ಪು ಋಣಿಯ ವಿರುದ್ಧ ನ್ಯಾಯಾಲಯವು ನಿರ್ಬಂಧಾಕ್ಷೆಗಾಗಿ ಹಸಲು ದಾವಾ ಸಂಖ್ಯೆ ನಂಬರ್ 246/2004 ಅಲ್ಲಿ ತೀರ್ಪು ಋಣಿಯ ವಿರುದ್ಧ ಡಿಕ್ರಿ ಮಾಡಿದ್ದು ತೀರ್ಪು ಋಣಿ
ಜಜ್ಮೆಂಟ್ ಡೇಟರ್.
ಎಸ್ ಡಿಗ್ರಿ ಹೋಲ್ಡರ್ ಸಾರಿ ಮೇ ತೀರ್ಪು ಋಣಿಯರು ಅಂದ್ರೆ ಡಿಗ್ರಿ ಹೋಲ್ಡರ್ ಎಸ್ ಡಿಕ್ರಿಯ ಪ್ರಕಾರ ನಡೆದುಕೊಳ್ಳದೆ
ತೀರ್ಪು ಋಣಿ
ಜಜ್ಮೆಂಟ್ ಡೇಟರ್ ಸಾರಿ ಜಜ್ಮೆಂಟ್
ನನ್ನ ಕನ್ನಡನು
ಜಜ್ಮೆಂಟ್ ಡೇಟರ್ ಪ್ರಕಾರ ನಡೆದುಕೊಳ್ಳದೆ ಉದ್ದೇಶಪೂರ್ವಕವಾಗಿ ತಪ್ಪಿದ್ದರಿಂದ ತೀರ್ಪು ಋಣಿಯ ವಿರುದ್ಧ ಕ್ರಮ ಕೈಗೊಳ್ಳಬೇಕೆಂದು ಕೋರಿ ಅಮಲು ಜಾರಿ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಡಿಕ್ರಿದಾರರ ಪ್ರಕಾರ ತೀರ್ಪು ಋಣಿಯು ಉದ್ದೇಶಪೂರ್ವಕವಾಗಿ ಡಿಕ್ರಿ ಆದೇಶವನ್ನು ಉಲ್ಲಂಘಿಸಿ ಸಿಟಿಎಸ್ ಸಂಖ್ಯೆ ನಂಬರ್ 61/1 ಸ್ವತ್ತನ್ನು ಕೆಡವಿ ನ್ಯಾಯಾಲಯದ ಆದೇಶದ ಉಲ್ಲಂಘಿಸುತ್ತಾರೆ ಎಂಬುದಾಗಿದೆ. ತೀರ್ಪು ಋಣಿಯು ಅಸಲು ದಾವಾ 246/2004 ನ್ಯಾಯಾಲಯವು ತಮ್ಮ ವಿರುದ್ಧ ಶಾಶ್ವತ ನಿರ್ಬಂಧಾಕ್ಷೆಯನ್ನು ಹೊರಡಿಸುವುದರ ಬಗ್ಗೆ ಒಪ್ಪಿಕೊಳ್ಳುತ್ತಾರೆ. ಸಿಟಿಎಸ್ ಸಂಖ್ಯೆ 61/1 ಸ್ವತ್ತು ಮಹಾನಗರ ಪಾಲಿಕೆಗೆ ಸೇರಿದ ಸ್ವತ್ತಾಗಿದ್ದು ಸದರಿ ಸ್ವತ್ತನ್ನು ಮಹಾನಗರ ಪಾಲಿಕೆಯರು ತೀರ್ಪು ಋಣಿಯ ಪರವಾಗಿ ಭೋಗ್ಯಕ್ಕೆ ನೀಡಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಡಿಕ್ರಿದಾರನ ಮತ್ತು ತೀರ್ಪು ಋಣಿಯ ಸ್ವತ್ತಿನ ಮೇಲಿನ ಹಿತಾಸಕ್ತಿಯು ಪೂರ್ಣವಾಗಿ ಮಹಾನಗರ ಪಾಲಿಕೆ ಇರುತ್ತದೆ. ಸಿಟಿಎಸ್ ಸಂಖ್ಯೆ 61/1 ಸ್ವತ್ತು ತೀರ್ಪು ಋಣಿಗೆ ಸೇರಿದ್ದರೂ ಸಹ ಸದರಿ ಕಟ್ಟಡವನ್ನು ನಿರ್ಮಾಣ ಮಾಡಿರುವುದು ಸ್ಥಳವು ಮಹಾನಗರ ಪಾಲಿಕೆ ಸೇರಿದ ಸ್ವತ್ತಾಗಿರುತ್ತದೆ. ಭೋಗ್ಯದ ಅವಧಿ ಮುಗಿದ ನಂತರವೂ ಸ್ಥಳೀಯ ಪ್ರಾಧಿಕಾರವು ಕಟ್ಟಡವನ್ನು ಕೆಡವಿರುತ್ತಾರೆ. ಸ್ಥಳೀಯ ಪ್ರಾಧಿಕಾರದವರು ಮಾಸ್ಟರ್ ಪ್ಲಾನ್ ಯೋಜನೆಯಲ್ಲಿ ಕೆಲವು ಮುಖ್ಯ ರಸ್ತೆಗಳನ್ನು ಅಗಲೀಕರಣಗೊಳಿಸುವ ಕಾರ್ಯವನ್ನು ಕೈಗೊಂಡಿರುತ್ತಾರೆ. ಸಿಟಿಎಸ್ ಸಂಖ್ಯೆ 61/1, 61/2 ಈ ಎರಡು ಕಟ್ಟಡಗಳ ಹಳೆಯ ಕಟ್ಟಡಗಳಾಗಿದ್ದು ಕಲ್ಲು ಮತ್ತು ಮಣ್ಣಿನಿಂದ ಕಟ್ಟಿದ್ದಾಗಿರುತ್ತದೆ. ಸ್ಥಳೀಯ ಪ್ರಾಧಿಕಾರದವರು ತೀರ್ಪು ಋಣಿಯ ದಿನಾಂಕ 4/10/2011 ನೋಟಿಸ್ ಸಹ ಈ ಸಂಬಂಧ ರಚನೆಯನ್ನು ಕೆಡವಲು ಮತ್ತು ಕಟ್ಟಡವನ್ನು ಬಿಡುವಂತೆ ನೀಡಿರುತ್ತಾರೆ. ಡಿಕ್ರಿದಾರರು ಸಹ ತೀರ್ಪು ಋಣಿಯ ದಿನಾಂಕ 7/10/2012 ವಿಷಯವನ್ನು ತಿಳಿಸಿರುತ್ತಾರೆ. ನಂತರ ಸ್ಥಳೀಯ ಪ್ರಾಧಿಕಾರವು ಮಾಸ್ಟರ್ ಪ್ಲಾನ್ ಯೋಜನೆಯಡಿಯಲ್ಲಿ ಕಟ್ಟಡವನ್ನು ಕೆಡವಿರುತ್ತಾರೆ. ಇಡೀ ಕಟ್ಟಡವೇ ನೆಲಸಮ ಆಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಡಿಕ್ರಿದಾರರು ಅಮಲು ಜಾರಿ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸುವ ಸಮಯದಲ್ಲಿ ಅಸಲು ದಾವಾ ಸಂಖ್ಯೆ 246/2004 ದಾವಾ ಅಂಗಡಿಯು ಅಸ್ತಿತ್ವದಲ್ಲಿ ಇರುವುದಿಲ್ಲ ಮತ್ತು ಕಾನೂನು ಪ್ರಕ್ರಿಯೆಯ ಅನುಸಾರವಲ್ಲದೆ ಡಿಕ್ರಿದಾರರು ತೀರ್ಪು ಋಣಿಯ ದಾವಾ ಸ್ವತ್ತಿನಿಂದ ಹೊರ ಹಾಕದಂತೆ ನ್ಯಾಯಾಲಯವು ಆದೇಶ ನೀಡಿದ್ದು ಪ್ರಸ್ತುತ ಪೂರ್ಣ ಕಟ್ಟಡವನ್ನೇ ಸ್ಥಳೀಯ ಪ್ರಾಧಿಕಾರವು ಕೆಡವಿರುವುದರಿಂದ ಡಿಕ್ರಿದಾರರು ಸಲ್ಲಿಸಿರುವ ಅಮಲು ಜಾರಿ ಅರ್ಜಿಯು ವಾಗಿರುವುದಿಲ್ಲ ಎಂಬುದಾಗಿ ಪ್ರತಿವಾದಿಸುತ್ತಾರೆ. ಡಿಕ್ರಿದಾರರ ಪರ ವಕೀಲರು ದಾವಾ ಸ್ವತ್ತು ಮಹಾನಗರ ಪಾಲಿಕೆ ವಿಜಯಪುರ ಮಾಸ್ಟರ್ ಪ್ಲಾನ್ ಯೋಜನೆಯಲ್ಲಿ ಬರುವುದಿಲ್ಲ. ಮಹಾನಗರ ಪಾಲಿಕೆ ದಾವಾ ಅಸ್ತಿತ್ವದಲ್ಲಿರುವ ಸಿಟಿಎಸ್ ನಂಬರ್ 61/1 ಅನ್ನು ಕೆಡವಲು ಯಾವುದೇ ಕಾರ್ಯವನ್ನು ಕೈಗೊಂಡಿಲ್ಲ. ದಾವಾ ಸ್ವತ್ತಿನ ಮೇಲಿರುವ ಡಿಕ್ರಿದಾರರ ಹಕ್ಕನ್ನು ಮೊಟಕುಗೊಳಿಸಲು ಕಸಿದುಕೊಳ್ಳುವ ಉದ್ದೇಶದಿಂದಲೇ ತೀರ್ಪು ಋಣಿಯು ನ್ಯಾಯಾಲಯದ ಅಸಲು ದಾವಾ 246/2004 ಹೊರಡಿಸಿದ ಶಾಶ್ವತ ನಿರ್ಬಂಧಾಕ್ಷೆಯ ಡಿಕ್ರಿಯ ಆದೇಶವನ್ನು ಉಲ್ಲಂಘಿಸಿರುವುದರಿಂದ ತೀರ್ಪು ಋಣಿಯ ವಿರುದ್ಧ ಸೂಕ್ತ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಅರ್ಜಿಯ ಪೂರ್ಣ ವಿಚಾರಣೆ ಅಗತ್ಯವಿರುತ್ತದೆಂಬ ಡಿಕ್ರಿದಾರರ ಪರ ವಕೀಲರು ಪ್ರತಿವಾದನೆ. ಈ ಅಮಲುದಾರ ಅರ್ಜಿಯನ್ನು ಡಿಕ್ರಿದಾರರ ತೀರ್ಪು ಋಣಿಯ ವಿರುದ್ಧ ಡಿಕ್ರಿಗೆ ಪೂರಕವಾಗಿ ನಡೆದುಕೊಳ್ಳಲು ಅವಕಾಶವಿದ್ದರೂ ಸಹ ಉದ್ದೇಶಪೂರ್ವಕವಾಗಿ ಡಿಕ್ರಿ ಆದೇಶವನ್ನು ಉಲ್ಲಂಘಿಸಿ ದಾವಾ ಸ್ವತ್ತು ಅಸ್ತಿತ್ವದಲ್ಲಿರುವ ಸಿಟಿಎಸ್ ಸಂಖ್ಯೆ 61/1 ಸ್ವತ್ತನ್ನು ಕೆಡವಿ ಆದೇಶವನ್ನು ಉಲ್ಲಂಘಿಸಿದ್ದಾರೆಂದು ಅಮಲು ಜಾರಿ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿದ್ದು, ತೀರ್ಪು ಋಣಿಯ ಮಧ್ಯಂತರ ಅರ್ಜಿ ಸಂಖ್ಯೆ 3 ಸಲ್ಲಿಸಿ ನೀಡಿರುವ ಕಾರಣಗಳ ಆಧಾರದ ಮೇಲೆ ಈ ಹಂತದಲ್ಲಿಯೇ ನ್ಯಾಯಾಲಯವು ತೀರ್ಪು ಋಣಿಯು ಉದ್ದೇಶಪೂರ್ವಕವಾಗಿ ಅಸಲು ದಾವಾ ಸಂಖ್ಯೆ 246/2004 ಡಿಕ್ರಿ ಆದೇಶವನ್ನು ಉಲ್ಲಂಘನೆ ಮಾಡಿದ್ದಾರೋ ಅಥವಾ ಇಲ್ಲವೋ, ಅಥವಾ ಮಹಾನಗರ ಪಾಲಿಕೆಯವರ ಮಾಸ್ಟರ್ ಪ್ಲಾನ್ ಯೋಜನೆ ದಾವಾ ಆಸ್ತಿಯನ್ನು
Now, where is the endorsement you said?
Lord, that endorsement I have produced in the Lord trial court. Lordship, that endorsement is with me. And now further development, Lord, your Lordship, may kindly see, on 28/10/2024, they themselves have issued a legal notice under the Lord to vacate the premises. Since allegation is that, Lord, I am not paying the rent regularly.
But ಅಲ್ಲಿ ಬಿಲ್ಡಿಂಗ್ ಇಲ್ಲ ಇವಾಗ.
Building ಇದೆ ಸ್ವಾಮಿಯಲ್ಲಿ. Yes, my lord, some portion of the building they have demolished. Now, my lord, it is a matter of, my lord, my submission is that whether it is demolished by the corporation or by the, my lord, decree holder, it has to be decided by the execution court. Let, my lord, they produce the documents and we will also produce. Let the, my lord, execution court to decide it. If it is demolished by the corporation, the execution petition will be dismissed. If they are demolished, it is matter of trial. That part the trial court observe that it is matter of trial. Not we cannot dismiss at the threshold on the basis of the application. That's why.
No, this is with respect to the same property.
Same property. It issued to me, and I have given a reply also for that. My humble submission is
temporary shed you have put up.
Yes, it is some portion of building. Still, I am continuing in the possession of the property. Let the executing court, my lord, record the evidence whether it is demolished by the corporation. If it is really corporation demolished, then, my lord, I will be out of the court.
Now, so if you want to construct a shopping complex,
Yes.
is there any right of re-entry?
Yes, sir, we have given a resolution because they have requested to show my bona fide even reconstruction. My lord, I will give. That's how. Page 60.
Page
64. 64, my lord. 71, my lord. 71, my lord. So we don't want to betray him. There are 100 years of there is entire mass encroachment was removed by the authorities in a master plan. There are all CDs are there. Compensation is paid by this court. 71, my lord. And they also requested, and we are agreed for it also.
Now, Mr. Patil.
Yes, ma'am.
They are making a counter offer at page 71.
Yes.
Now, in case you get instructions.
Yes.
If this is there, then we could record it.
Yes.
And dispose it of.
I undertake.
If the offer that they have made, you get instructions.
Yes, ma'am.
The offer they have made at 71.
Yes.
Page 71.
ಅಲ್ಲ ಅದು ನಮಗೆ ಒಂದು ಹೇಳಿದ್ರು ಏನೋ ಸಮ್ ಸೆಟಲ್ಮೆಂಟ್ ಈಸ್ ಗೋಯಿಂಗ್ ನಾನು ತಂದ್ರು ಬಟ್ ದಟ್ಸ್ ವಿಲೌಟ್ ಸೆಟಲ್ಮೆಂಟ್ ಐ ಆಮ್ ಆಲ್ಸೋ ನಾಟ್ ಅವೇರ್ ಅಬೌಟ್ ದಟ್.
So just see page 71.
They conciliated and then he requested and we have given undertaking.
In this, yes. I will take instruction.
Now in case affidavits could be filed
Yes.
affirming this.
Yes.
That, but you have to construct.
Yeah, we are constructing. Okay, I'll construct and I will give my lord undertaking then. Within stipulated time, wherever there will be, sir. We don't want, because there are old buildings, some 50, 60 years building over there. There was an encroachment on the lane. Therefore, in a mass, sometimes what happened, my lord, in this master plan, authorities are dismantling the property like anything. Sometime owner to save their other properties because they will use heavy bulldozers. It will affect the entire building. Therefore, with the consent of the authorities, sometimes the owners also were removing encroachment. There are instances. So it is not that we don't want to remove him. If I am removed only this person, then it can be attributed to me and that I had any malafide intention against this tenant for removing him. Entire bazaar has been removed, my lord.
Could you find out, take insight?
Yes, I will take.
Third, counsel for the petitioner draws attention to annexure J and submits there's an offer of re-entry upon construction of the building. It's further submitted that if this offer is taken note of, the entirety of the dispute itself would be solved. Counsel for the respondent submits necessary instructions would be taken.
Yes.
Party is only scared. It can, you may say, act of God.
Yes.
No. We will undertake, my lord. Date 27. Other matter.
ಅದು ಡಿವಿಷನ್ ಬೆಂಚ್ ಆದ್ಮೇಲೆ
ಅದೇ
first week of March, Lord, 1-2 I will take.
Relist the matter in the first week of March.
Number 9, DP Ambedkar.
Please, madam. Plaintiff's writ petition being agreed by the rejection of his application for appointment of court commissioner. I number 7.
Now, who's the other side?
Other side, my lord, I think is personal inconvenience ಇದೆ ಅಂತೇನು. ಸಂಗನ್ ಬೋಸಾಬಿ ಪಾಟೀಲ್ some personal inconvenience ಅಂತ.
Relist the matter next week.
Any date, please. There is an interim order, I think, operating.
Modern operation is extended till the next date.
Please.
7. 8. Interim operation.
10, Abdul Muqtadir.
My lords, I am appearing for defendant, my lords. Plaintiff has filed a suit for perpetual injunction, my lords. My lords, I have challenged the marking of the document, which is unregistered document, my lords.
It will be looked for collateral purpose.
But my lords, in para 3 of the plaint, my lords, the plaintiff is relying completely on the unregistered document, my lords. I'm producing the judgments as to that, my lords.
You're correct. What we are saying now, anyhow, what is the order of the trial court? They have marked it or not marked?
They have marked it, my lords. Page number 31, my lords. Page number 31, my lords.
So now what remains?
After payment of deficit and penalty paid by the plaintiff, the document mark
is different. Registration is different.
In spite of that, my lords,
Okay, you read that. Let us.
Please, my lords. Order,
page 31.
Please, my lords.
Read.
The counsel for the defendant submits that the said document is not registered.
So where are you reading? Read from the first case.
Please,
called
my lords.
against.
Case again called out, PW1 present and further chief examination, defendant counsel present at the stage of further examination in chief. The learned counsel for defendant objects the marking of unregistered agreement of sale after payment of deficit stamp duty and penalty. The counsel for defendant submits that the said document is not registered even after paying deficit stamp duty and penalty. The document cannot be marked in evidence. The learned counsel for the plaintiff present at this stage, the court places reliance on our own Honorable Court of Karnataka in judgment K. Amarnath versus Srimati Puttamma on 13 July 2000, equivalent citation ILR 1999 KAR 4634-2004, Karnataka Law Journal 55. In this said judgment, the Honorable Court has elaborately dealt regarding the marking of the document and the ratio decedently laid in that whenever any unregistered document is insufficiently stamped document is produced by any party to the suit, then the court at the primary stage itself, the document needs to be impounded, and after paying sufficient stamp duty, stamp duty and penalty, the document produced by the party can be marked. Therefore, in this case, the plaintiff has produced unregistered agreement of sale and the same is impounded, and after collecting deficit stamp duty and penalty at the stage is set down for marking of the said document, and the same need to be marked as Exhibit P1. Since sufficient deficit stamp duty and penalty paid by the plaintiff, therefore the objection raised by learned counsel for the defendant stands rejected. In respect of the submission that even
Now,
after...
just one minute. Now we could do one thing.
Please, Madam.
Insofar as stamp duty penalty may be paid. That's one
That
part
is
of it.
paid, my lords.
That's one part of it.
Please, my lords.
Your objection is that the document is not registered.
Please, my lords.
Under section 48.
49 of Registration Act. 49.
49. Registration Act. It can be
Effect of non-registration of documents required to be registered. Please, my lords. The proviso says that an unregistered document affecting immovable property that comes, my lords, collateral transaction will not come into picture because the plaintiff is relying his title completely on the...
We'll clarify.
Please, my
we
lords.
could clarify
Please, my lords.
that the trial court is to record a finding
Please, my lords.
as to whether the document requires registration in terms of section 17.
It requires, my lords. Please, my lords.
Okay, that's your argument.
Please, my lords.
We'll ask the trial court to record a finding.
Please, my lords.
One, whether it requires registration in terms of section 17.
Please, my lords.
If not, for what limited purpose under section 49?
49, my lords. 9 of Registration Act.
Under section 49, for what purpose it can be relied on?
It can
we'll
be...
ask the trial court to record a finding on that.
Please, my lords. They have relied on the judgment, my lords, but they have not looked into it properly, my lords. I'm producing memo of
Now
judgment.
the trial court has not adverted to that aspect in
Please,
this
my lords.
order.
Please,
It
my
is
lords.
only commented regarding stamp duty and penalty.
Penalty, please, my lords.
So we'll record what you are saying
Please, my lords.
and ask the trial court to record a finding as to whether the document is now marked as exhibit
P1, my lords.
P1
Please, my lords.
is to be registered in terms of 17.
Please, my lords.
If it requires to be registered and finding in the affirmative, then to state whether under 49 and to what extent and dispose it.
Please, my lord. But at trial court, it is at the stage of argument, my lords.
Correct. So now we'll say, because
Please.
now at the time of arguments,
Please,
question of appreciation of that document, etc., will come into play.
Please,
So
my
we'll direct the trial court to record a finding so that at the time of argument, parties can take benefit of such observation.
Already an interim stay is granted not to pronounce the judgment, my lords. It has.
Now we'll say, prior to the resumption of argument, trial court must hear both parties, record a finding whether
Please,
the
my lord.
document exhibit P1 requires to be registered under section 17.
Please, my lord.
If not, what is the limited purpose for which it can be relied upon, whether in terms of 49 or otherwise. And after making such recording, matter may be taken up for
Please.
final argument.
Please, my lords.
Please. Present petition has been filed by the defendant before the trial court. Calling in question marking of agreement of sale dated 26/11/1995 at Exhibit P1 by the trial court. Full stop. It is the specific case of the defendant. Male parties are referred to by the rank before the trial court for the purpose of convenience. It is the specific case of the defendant that at the time of marking of the document, an objection was raised on two grounds. One, regarding document not being stamped, and two, regarding the document not being registered. It is submitted that insofar as the objection regarding stamp duty,
Please.
document was impounded
Yes, my lords.
and stamp duty has been paid.
After impounding, they have marked it again, my lords. Like,
No, after payment of
However,
deficit court fee,
Please,
they
ma'am.
retain.
however, the objection for against marking of the document on the ground that the document required registration was not accepted by the trial court,
please, my lords.
and trial court has proceeded to mark the document.
Please, my lords.
Full stop. It is submitted that the trial court has grossly erred in ignoring the objection regarding the requirement of registration of the document and failed to record any finding in that regard, while merely observing that the stamp duty has been paid on the said document. Learned counsel for the plaintiff submits that during the course of argument, it's for the trial court to consider as to whether the said document was required to be registered, and if so, whether it could be looked into for collateral purpose. Full stop. It's further submitted that if the court were to record a finding that the document does not require to be registered, then the same may be taken note of. Full stop. Next. Peruse the order dated 2/11/22. From 22 it's pending.
Please, my lords.
Next.
The proceedings are not stopped, my lords.
Huh?
The proceedings are not stopped. They are proceeding, my lords.
It's
in
going
trial.
only for pronouncement of judgment.
Is waiting.
Please, my lords.
Next. The trial court now, what does the judgment say? What is the legal position according to you?
My lords, if the plaintiff is relying completely on the document for like based on title, then it won't come under collateral transaction, my lords.
Correct, but that's a matter for appreciation at the time of argument,
Please, my lords.
isn't it?
Please, my lords. I have judgments which
Now,
says.
what does it say?
Please, my lords.
At the time of argument,
Now the
court
stage
will look into it.
Now the stage for argument.
Stage is
trial court.
argument.
So,
At the
during
time
that
of
stage,
argument,
Please, my lords.
it could look into whether it requires to be registered. If yes, then whether it can be used for collateral purpose. That's a matter the court, just before it takes up for final argument, may record a finding and then proceed.
Please, my lords.
Next. The last time. The trial court has noticed that deficit stamp duty and penalty has been paid and has proceeded to mark the document. So far as the objection that in spite of stamp duty and penalty having been paid, document is not to be marked because it requires registration has been overruled. Full stop. Next. It must be noticed that mere marking of the document would not have the effect of curing the defect of document if it requires registration. Next. If the trial court to record a finding as to whether the document is compulsorily registrable, requires to be registered in terms of section 17.
17 and 49.
Huh?
17 minutes.
17 of the Registration Act. Full stop. In the event the court were to record an affirmative finding that the document requires to be registered in terms of section 17, then the trial court to also record a finding whether it could be relied upon in terms of section 49. Full stop. Next. However, if the court were to record a finding that the document does not require registration, then a finding on such effect is also to be made. In light of such observations, petition is disposed of. It is made clear that in light of the observation made above, trial court to record a finding prior to taking up the matter for final arguments. Both parties to mark their appearance without notice on
next
date code.
Any day.
12th of March.
Please minutes.
Accordingly, petition is disposed of subject to the above observation. Full stop. It's made clear that the marking of the document by itself does not have the effect of overruling the objection of the petition of the defendant that is kept open in light of the observation made above.
Obligement.
11, Sanjeev Kumar Tripathi. Nagraj Patil for respondents.
Lord, in this case, the challenging the order of the Lord trial court dated 14/11/22, wherein the plaintiff has filed a suit for bare injunction against the respondent, contending that he has purchased the suit plot bearing 30x40 in plot number 46 from one Shakuntala Bai, wife of Kallappa, on 13/6/2008. The defendant number 2 is the daughter of that said Shakuntala Bai, and defendant number 1 is the husband of that.
Now, at the time of evidence, what was the objection raised?
Lord, objection raised, it is an unregistered sale deed. Time to mark the document, court has rejected it. Now, my only one contest says it is a suit for bare injunction. It can be used for collateral purpose. This honorable court, while granting interim order, also says that this document can be marked for only for collateral purpose, and trial should go on, not to pass the final order. That is the.
What is the judgment show?
Lord, that judgment. Lord, I have the other judgment. Sir, then the judgment over.
Yeah.
2001-3.
PSCC 1.
SCC volume 2001 volume 3. I have not other judgments also on the very same point.
Supreme Court, yeah.
Supreme Court.
Kodi.
In Bondar Singh case 2003 Supreme Court
Yeah.
and other high courts judgments also there, my lord.
One clear ಆಗಿದೆ.
Even the unregistered document can be, my lord.
Correct. It can be marked.
Yes.
The court has to
Only
determine.
for I'm not seeking, my lord, title based on that unregistered document. I'm seeking only injunction, protect my. I am in possession of the property by virtue of that unregistered. So lordship may kindly see paragraph 5 of the, my lord, judgment. The main question, as we have already noted.
Just one minute.
Watch. The main question, as we already noted, is the question of continuous possession of the plaintiff over the suit land. The sale deed dated 9/5/1931 by Fakir Chand, father of the defendant, in favor of the Tola Singh, the predecessor in interest of the plaintiff, is an admitted document in the sense its execution is not in dispute. The only defense set up by the against the said document is that it is unstamped and unregistered, and therefore it cannot convey title to the land in favor of the plaintiff. Under the law, a sale deed is required to be properly stamped and registered before it can convey title to the vendee. However, legal position is clear law that a document like the sale deed in the present case, even though not admissible in evidence, can be looked into for the collateral purpose. In the present case, the collateral purpose to be seen is in the nature of position of the plaintiff over the suit land. The sale deed in question at least show the initial position of the plaintiff over the suit land was not an illegal or unauthorized. It is significant to note that sale deed dated 9/5/1931 and the Fakir Chand died somewhere in the year 1949-50. During his lifetime, Fakir Chand never disputed the plaintiff title or position of the suit land.
Correct. Now, what is the point now?
My lord, my point is, my only submission is that it can be marked for the collateral purpose because my vendor, my lord, now died. Now the defendant they claim that they are the daughter. Now they are disputing my possession. Therefore, I filed a suit for bare injunction. Your mother has sold me under the unregistered lady. It can be marked, my lord, for the.
At least to show that you are in
I am in possession of property. I am not seeking any declaration.
So who appears for the other side?
And one Andhra Pradesh High Court on the same facts, my lord, the suit for injunction, mere injunction that can be marked.
Here, what has the trial court done?
Trial court, my lord, says that it is
rejected the objection.
it is unregistered, my lord, reject. Only on the point of sections refer to section 17 of the Registration Act and say that sale deed is required to be compulsory registered.
No, but he has to come. Let us see. Interim order, yeah.
Interim order is that only not to pass the final order on this. Our trial is going on, and this honorable court directed to for the purpose of evidence
Pronounce judgment.
not to pronounce. Let the mark document evidence. So defendant evidence.
But it's a settled position. Court can see whether it requires to be mandatorily registered.
Yes.
Even otherwise, under 49.
49
it can be looked at and mark it only for that limited purpose.
Only limited purpose. That is the only my prayer.
No representation on behalf of the other side. ಇದು ಕಳಿಸ್ಕೊಡಿ ಹಿಂದಿನ ಮ್ಯಾಟರ್ ಬೇಕು.
Sagar Patil.
He was here, no?
He was just here.
ಬರ್ತಾರಾ? What is the order challenged?
The Lordship, daughter has filed a, father has filed a suit for declaration injunction. Father has filed a suit for declaration injunction. Meanwhile, he was expired during the pendency of the suit.
Suit for injunction.
Declaration injunction
Was filed
against daughter, some others party, Your Lordship.
by the father.
Father. He was. Thanks.
My lord, the petitioners of the defendant before the trial court, the father of the petitioners had filed a suit for declaration to declare that the suit properties are his self-acquired properties
That is filed
against the son and daughters, wife, son and daughters.
wife, son and daughters.
Suit for declaration. To declare that the plaintiff is the absolute owner of the suit lands, and further, if the trial court finds that if the plaintiff is not in possession of the suit land, to decree to pass a decree for recovery of possession. My lord, when the matter was pending, the father died, my lord. Died. Then the respondent number 3, that is defendant number 3, files an application under order 1 rule 10 to transpose her as a plaintiff on the basis of a will, my lord, which is not permissible. If lordship looks, I may take your lordship to the relevant portion of the order, which is totally an unreasoned order.
If there is a will under order 22, rule 9.
Yes.
Yes. And as a legatee.
Legatee, she has to first, an inquiry has to be held, but in that will also, not only she is the one beneficiary, all the defendants are the beneficiaries. So it is only a suit for declaration. Her there in that suit, my lord, she has filed a WS claiming counterclaim to pass a decree for partition and separate possession. Once there is a counterclaim for partition and separate possession, the suit which is only for a declaration, she cannot be transposed as a plaintiff to contest the suit for declaration, which is against the defendants themselves, my lord.
So what she filed, what application did she file?
Order 1 rule 10, my lord, to transpose her as a plaintiff. No, 1 rule 10 transpose madak barangilla. Yes, my lord. Application is at page number 46.
Transposition is order 1 rule 9.
No, yes, it is order 1 rule 10. She has filed an application.
1 rule 10 is impeding, is it?
Yes, my lord. But she has filed an application to transpose. That application itself is not maintainable. Page number 46. Order 1 rule 10 1 rule 10 is, my lord, in respect of suit.
Even let's assume it to be treated as one under order 22 rule 9.
Yes.
Let there be an
Inquiry
under order 22 rule 5.
Yes, my lord. Inquiry has to be held. Even that will not be permissible, my lord, because will not, she alone is not a party to the, she alone is not a beneficiary to the will, my lord. Here it is a suit for declaration.
Now what is the order passed?
Order passed is at page number, page 60, my lord.
Page
60, 60. I may permit it to read, my lord, from para 2. In the said application, it was contended by the applicant that his father had instituted the present suit seeking for relief of declaration and injunction. His father died, it is actually her, my lord, his father died on 18/5/2022. During the lifetime of his father has executed a will in favor of the applicant. The said will has been produced along with IN number 5, which was already allowed on 3/1/22. He has filed return statement and counterclaim in the matter. Hence, he prayed to permit him to transpose himself from defendant number 3 to plaintiff.
IA number 7, the applicant defendant number 3 has further contend that his father died on 18/5/22. His himself defendant number 1, 4, 5 and 6 are legal heirs of deceased plaintiff. During the lifetime of the plaintiff had executed a will in his favor. By virtue of said will, he is claiming right over the property. He has also prayed to set aside the abatement of suit because of death of plaintiff. The accompanying affidavit to IA number 8, the applicant defendant number 3 has prayed to condone the delay. Para 5. To all the above 3 applications, the defendant number 1, 2, 4 and 5 have filed their objection, containing that defendant number 3 cannot be allowed to transpose herself as plaintiff, as it can be permitted only when the suit is withdrawn or abandoned by the plaintiff. But in the case in hand, the plaintiff has died. In such situation, as per the proviso of Order 23 Rule 1A, he cannot be transported as plaintiff. The defendant number 1, 2, 4 and 5 further objected that the will relied on by the defendant number 3 is a created one, fabricated one. Once they prayed to reject IA number 6 to 8. On pursuit of the entire material available on record, in the opinion of the court, the petitioner who has approached to be transposed as plaintiff as some case having nexus to the suit claiming. Hence, it is desirable to implead him as a party rather than refusing transposing. The defendant number 3 has filed a counterclaim before the court, praying the court to effect partition and deliver his share of his mother. Now, the defendant number 3 contends that his father, who has sought for declaration, had executed a will in his favor. Being legatee under the will, he has become owner of this said property. Already it is declared, my lord. Hence, he had prayed to transpose him as a party to the suit. Therefore, in the opinion of the court, to afford grounds for final decision upon the subject in dispute and to prevent further litigation concerning them to dispose of the matter on merits, it is just a necessity to allow the present IA number 6. This next is, my lord, to condone delay. In a suit for declaration, my lord, where the father himself has filed a suit against the children, saying that he is to declare him as the owner. Now, the defendant number 3 cannot transpose herself as a plaintiff and contest this suit because prayer cannot be altered. The prayer sought for the father was to declare him as the owner against the.
It has to abate, keeping.
It has to abate. She has to file a fresh suit, my lord. She has to file all the contention. She has to file a fresh suit. The suit itself gets abated because it was.
Yes, for her.
My lord,
Well, kindly pass over the matter. Seniority.
They're only saying that separate proceedings you can take. Nothing prevents you. That we will keep it open.
Yes, sir. Always there is no any. I have no any.
Let us see. Time permits. I may not sit in single matters post lunch. Anyhow, I'll pass over.
Please.
In case they are agreeable, we can dispose.
Please, ma'am. Please.
Number 18, Basavaraj Kareddy.
Serial number 18, Lordship. I am for behalf of the Kareddy, sir. He is not in station, Lordship. Kindly have it in next week. Some personal inconvenience.
18 matter is adjourned. What about the other matter? Last time also nobody came.
ಹೌದು ಈಗ ಬೆಳಗ್ಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅವರು
ಅವರಿಗೆ ಮ್ಯಾಟರ್ ಹೋದ್ ಸತಿನೂ ಬಂದಿಲ್ಲ.
ಹೌದು ಸರ್, ಅವರಿಗೆ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಡಿದ್ದೀನಿ ಸ್ವಾಮಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನಲ್ಲೇ ಇದು ಮಾಡ್ತೀನಿ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನಾನು ಕಳಿಸ್ಬಿಟ್ಟು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂದ್ರೆ ಹೆಂಗ?
27th Lordship.
Only one exception, some interest. This will have to come in, but you just see now what he's only saying, that in so far as undisputed, let the FDP proceed. Multiple decrees can be passed. That's all he's saying. So you are in so far as you are this different matter.
This is a different matter. Yes,
so that's all he's saying. He's saying let the FDP, multiple FDPs can go on where the matter is settled between both the parties. That's all.
27th or 28th Lordship, I will inform to him.
27th, I'll put it. Let us.
Please, Lordship.
It's a old matter. That's all. Otherwise, we have no interest.
Please.
Old matter. If it could be bifurcated, and where there is no dispute amongst the sharers, and settlement has entered into, that could be, we could ask the court to go ahead and pass a decree insofar as the undisputed. Just find out if it is a their instrument.
Please. 27. Great.
Number 20, Ganesh Kalaburagi.
Relist week after next.
Then serial number 16 interim order has to be extended.
Serial number
16 interim order has to be extended, my lord.
CPC is better than writ appeals.
Yes.
Three is posted on 27th, no? 3, serial number 3. 27th, ala? Yes.
Sir, madam.
ಸರ್ ಮಾಜನ್ ಸರ್ ಹೋದ್ರ? ಸರ್ ಥ್ಯಾಂಕ್ ಯು ಸೋ ಮಚ್. ಚೆನ್ನಾಗತ್ರಿ ಸರ್. ನೀವು ಹೋದ್ ಸರ ಬಂದಾಗ ಹೇಳಿದ್ ನೆನಪಿತ್ರಿ ಸರ್ ನನ್ಗೆ. ಥ್ಯಾಂಕ್ ಯು ಸೋ ಮಚ್ ಸರ್, ಚೆನ್ನಾಗೈತಿ ಸರ್. ಹಾ ಸರ್. ನಿಮ್ ರಿಲೇಟಿವ್ ಯಾರೋ ಒಬ್ರು ಬಂದಿದ್ರಿ ಸರ್, ಪಾಪ ಅವ್ರು ವೇಟ್ ಮಾಡಿ ಇದನ್ ಮಾಡಿದ್ರು. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಫಸ್ಟ್ ಮ್ಯಾಟ್ 25th ಕೊಟ್ಟು
ಬ್ರಾಕೆಟ್ ಇಲ್ಲ
ಡಿವಿಷನ್
ಡಿವಿಷನ್ 25th ಸರ್.
ಏನಾಗಬೇಕು 192 194 ಏನಲ್ಲ 3 ಸಬ್ಸೆಕ್ಷನ್ 3 ಇದೆ. ಸೆಕ್ಷನ್ ಹೌದು. ಇಯರ್ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಹಾಕಿ
ತಗೊಂಡು ಬಿಡಿ. ಎಂಡಾಸ್ ಹಾಕಿಲ್ಲ ಸೀರಿಯಲ್ ಮಟ್ಟು
ಈ ಕಳ್ಸೋಣ.
ಏನೋ ಬಂದ್ ಕುಂತಿದ್ದೆ ರೇಟ್. ಇದು ಸಾಹೇಬ್ರು 27ನೇ ತಾರೀಕು 2 ಮ್ಯಾಟರ್ ಸಿಂಗಲ್ ಕುಂದಿರ್ತಾರೆ ಯಾದವ್ ಸಾಹೇಬ್ರು. ಸೊ ಅದೇನು BC ಎಲ್ಲ ಏನಲ್ಲ, ನೀವೇ ಮಾಡ್ಕೋಬಹುದಲ್ಲ. ಕೇಳಿದ್ರು ಕಲಬುರ್ಗಿದೆ. ಇದನ್ನ ನೀವು ನೋಟ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ರಿ, ಮತ್ ನೀವು ಬೇರೆ ಹತ್ರ ಎಲ್ಲ ಹಾಕಂಗಿಲ್ಲ. 27th ಆಫ್ಟರ್ ಕಂಪ್ಲೀಷನ್ ಆಫ್ DB ಅಂತಾರೆ ಹಾಕ್ರಿ, ಅಥವಾ ಟೈಮಿಂಗ್ ಸಾಹೇಬ್ರನ್ನ ಕೇಳ್ಬಿಡ್ರಿ ನೀವು. ನಾನು ನಿಮ್ಗೆ ಇದನ್ನ ಹೇಳ್ತೇನೆ ಅಷ್ಟೇ, ನಂಬರ್ ಹೇಳ್ತೀನಿ ಯಾವ್ದಂತ. WP 202862 of 24. ಧಾರವಾಡಕರ್ ಸುಬೋಧ್ ತ್ರಿಪಾಠಿ ಅಂತ ಹೇಳ್ತೀನಿ. ಅವ್ನಿಗೊಂದು ಫೋನ್ ಮಾಡ್ಬಿಡ್ರಿ. ಇದು ಕಂಪ್ಯೂಟರ್ದವ್ರಿಗೆ ಒಂದೇ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಇಲ್ಲ, ಬೇರೆ ಬೇರೆ ಲಾಗಿನ್ ಆಗ್ಬೇಕು. ಒಬ್ರಿಗೆ ಇದಾಕ ಇಲ್ಲಿ ವೀಕ್ ಅನ್ಸೋಲ್ಲ ಅಲ್ಲ, ನಾನು ಹೇಳೇನಿ. ಒಮ್ಮೆ ರಿಮೈಂಡ್ ಮಾಡ್ಬಿಡ್ರಿ. ಆಮೇಲೆ ಇನ್ನೊಂದು WP 201946 of 21. ಮೊಹಮ್ಮದ್ ಅಬ್ದುಲ್ ಖೈಮ್ ಅಂತ. ಇದು WP ಬಂದ್ರು ರೀ, ನೀವು ಮತ್ ಬೇರೆ ಪೋಸ್ಟ್ ಮಾಡಂಗಿಲ್ಲ. ಈ ಸಾಹೇಬ್ರಿಂದ ನೀವು ತರಿಸ್ಕೊಂಡೇ ಇಟ್ಕೊಂಡ್ಬಿಡ್ರಿ, ಸೋಮವಾರಕ್ಕೆ. ಅಲ್ಲ ನೀವು ಬೇರೆ ರೀತಿ ಅದಕ್ಕೆ ಗುರುವಾರ
ಎರಡು EP ಮ್ಯಾಟರ್ ಬಂದಿದ್ದಾವೆ.
ಹೌದಾ, ಒಂದು ಸಾಯ್ಬೇಕು. ಇದು ನನಗೆ ಓಪನ್ ಕೋರ್ಟಲ್ಲಿ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿರ್ತೀನಿ. ಇವೆರಡು ಡೇಟ್ ನೋಡ್ರಿ, ಮತ್ತೆ ನೀವು ಅದನ್ನ ಬೇರೆ ಮುಂದೆ ಹಾಕಂಗಿಲ್ಲ. ಸಾಹೇಬ್ರಿಂದ ಸಿಗ್ತಾರ. ಇವು ಒಂದು TDS ಭಾಳ ದಿನದ ಹಳೇದೈತಿ ಕೇಸ್. ಸೊ ಅದು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ರು ಮುಗಿಸ್ಲಾಕ, ಏನು ಅದ್ರ ಮೇಲೆ ಲಾ ಯಾವುದಿಲ್ಲ ಅಂತ. ಸೊ ಟೈಮ್ ಪರ್ಮಿಟ್ ಆದ್ರೆ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ಇದು ಇನ್ನೊಂದು 50 ವರ್ಷದ ಕೇಸ್ ಐತಿ. 50 ವರ್ಷ ಅವ್ರ ಕರೆಂಡಿ ಬರ್ತಾ ಇಲ್ಲ. ಸೊ ಅದಕ್ಕೆ ಅವ್ರು ಮತ್ತೆ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ವಿ ಪದೇ 4 ಸಾಹೇಬ್ರ ಆಗ್ತಿ. ಆಯ್ತು ಅವತ್ತು ನೋಡ್ತೀನಿ. ಅವಾಗ ನಿಮ್ಗೆ ಧಾರವಾಡ ಇವು ಕಲಬುರ್ಗಿ ಬ್ಯಾಟ್ರ್ ಪರ್ಮಿಷನ್ ಅವಶ್ಯಕತೆ ಇಲ್ಲ, ಸಿಂಗಲ್ ಜಡ್ಜ್ ಇರ್ತೈತ.
ಪರ್ಮಿಷನ್ ಅವಶ್ಯಕತೆ
ನೋಡ್ಕೊಂಡ್ಬಿಟ್ರಿ
ಇರ್ತಾರೆ. ಅವಾಗ ಅವ್ರು ಕೇಳ್ಬೇಕಾಗತ್ತೆ, ಅವ್ರೇನ್ ಮಾಡ್ತಾರೆ
ಕಂಪ್ಲೀಷನ್ ಆಫ್ ನೀವು ಟೈಮ್ ಹೇಳ್ಕೊಬಿಟ್ರೆ ಆಫ್ಟರ್ ಕಂಪ್ಲೀಷನ್ ಆಫ್ DB ಅಂತ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಟೈಮ್ ಕೊಡೋಕ್ಕಿಂತ 2:30 ಆಫ್ಟರ್ ಕಂಪ್ಲೀಷನ್ ಆಫ್ DB ಅಂತಂದ್ರೆ ಎಲ್ಲ ಕೇಳ್ರಿ. ನಿಮ್ದೇನು ಟೆಕ್ನಿಕಲ್ ನೋಡ್ರಿ, ನಾವು ಅದನ್ನ ಗೈಡ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ. ಸೊ ಇವೆರಡು ಹೇಳ್ಯಾರ ಅಂತ ನೀವು ಮಂಗಳವಾರ ತಗೊಂಡ್ರೆ ಯಾಕಂದ್ರೆ ಬುಧವಾರ ರಜೆ ಐತಿ. ಆಮೇಲೆ ಡಿಕ್ಟೇಟಿಂಗ್ ಜಜ್ಮೆಂಟ್ ಐತಿ, ನಾಳೆ ಬರ್ತೀರಾ? ಸೋಮವಾರ ಬಿಡ್ಲಾ? Hearing number 57, the name is criminal appeal. 200 114 of 16. Karnataka for dictating judgment. ಇದರಲ್ಲೇ ಕೈಯಲ್ಲಿ ಮುಚ್ಚಿಕೊಂಡು ಡೇಟ್ ಇದೆ ನೋಡಿ, ಇದು ಫೈಲ್ ಬರಲ್ಲ ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ 200 115 ಆಫ್ 17. ಆಮೇಲೆ ಇದು ಒಂದು ಸೇಮ್ ಸ್ಟೇಜಿಗೆ ಮಾಡಿ ಕ್ರಿಮಿನಲ್ ಅಪೀಲು 200 233 ಆಫ್ 24. ಇದು ಆರ್ಡರ್ಸ್ ಮೆಮೊ ಇಲ್ಲಲ್ಲ, ಇದು ಸೇಮ್ ಸ್ಟೇಜ್ಗೆ ಬರಲಿ. TCR ಬರ್ತೈತಿ, ಇದು ಫೈಲ್ ಮುಗೀತು. ಥ್ಯಾಂಕ್ಸ್.
TCR ಬರ್ತೇನೆ
ಹಾಂ ಬರ್ತೈತಿ, ಟೆಲಿಫೋನಿಕ್ ಡಿಸ್ಪೋಸಲ್ ಮಾಡಿ ಫೈಲ್ ಹೋಗೈತಿ. ಇವು ಎರಡು ಮಾತ್ರ ನಿಮ್ಗೆ ಬರೋದು. ಇದು ತಗೊಂಡು ಹೋಗ್ತಾ
ಹಾ.
ಇದ್ದೀನಿ. ಮೇಡಮ್ ಈಗ DB ಐತಲ್ಲ, ಫಸ್ಟ್ ವಿಜಯ್ ಕುಮಾರ್ ಪಾಟೀಲ್ ಸಾಹೇಬ್ರ ಜೊತೆ, ಆಮೇಲೆ ಇವರು ಹುದ್ದಾರ್ ಸಾಹೇಬ್ರ ಜೊತೆ, ಆಮೇಲೆ ಸಿಂಗಲ್ ಇದೆ. ಅವು ಮೂರು ಬೇರೆ ಲಾಗಿನ್ ಆಗ್ಬೇಕು. ಅಲ್ಲಿ ನೀವು ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡ್ತೀರಾ ಅವ್ರ ಚೇಂಬರ್ಗೆ? ಹೇಳಿ. ನಮ್ದು ಸಾಹೇಬ್ರದ್ದು ಸಿಂಗಲ್ ಇದ್ದಾಗ ನಮ್ಗೆ ಪ್ರಾಬ್ಲಮ್ ಆಗಲ್ರಿ. DB ಇದ್ದಾಗ ಸರಿ. ಹಾಂ ಸರಿ.
ಒಂದು ಫೈಲ್ ತಗೊಂಡು ಮಧ್ಯಾಹ್ನ
ಅಲ್ಲದಾವ
ಟೊಮೆಟೊ
ತಗೊಂಬಂದ್ರೆ ಅವ್ರು ಕೊಟ್ಟಿದ್ದು. ನಂದು ಲೇಟ್ ಆಗ್ತದೆ ಸರ. ನಮ್ದಾದ್ರೆ ಆಮೇಲೆ ನಾಲ್ಕು ಇರಿಸಿದಾವೆ. ನಾಲ್ಕು ನಡೀತು ಹೋಗ್ತದೆ. ನಮಗೆ ನಿಮ್ಗೆ ಎರಡು ಹೇಳಿದ್ರೆ ಬರ್ತಾನೆ ಬಂದಿರ್ತಾನೆ ಅಂತ ಇದೇನು ತಲೆ ಸುತ್ತಬಿಡ್ತಾನೆ ವೆಲ್ಕಮ್ ಟು ಅಷ್ಟೇ ಸರ್ ಆರ್ಡರ್ ಎಷ್ಟಾಗಿದೆ ಅಲ್ಲಿಂದ ಅಡ್ಡಾಡಿದೆ ಅವ್ರಿಗೆ ಮಟ್ಟ ಹಾಕಂದ್ರೆ ಸರ್ ನನಗೆ ನಾವೇನಿದೆ ನನ್ ಕೇಳ್ಬೇಕು ನೆಕ್ಸ್ಟ್ ನಾ ಇಲ್ಲ ಅವ್ರಿಗೆ ನೆಕ್ಸ್ಟ್ ಗೀತಾ ನಾವೇನು ಹೇಳಿದೆ ಬರೋದು ಗೊತ್ತಿಲ್ರಿ ನೋಡಿ ಗುಲಾಬಿ ಫ್ಯಾಮಿಲಿ ಜೊತೆ ಸೀನಿಯರ್ ಹತ್ರ ಏನು ಮಾಡ್ತಾರೆ ಹೆಂಗೆ ಬೇಕು ಮನೆ ಬಾಚು ಅಂದ್ರೆ ಗೀತಾ ಕೊಟ್ಟಿದ್ದೇನು ಹೇಳಕ್ಬಾರ್ದಂತೆ ಮಾನಸ್ ಬರೀ ಬೇರೆ ಮಾತಾಡ್ತಾರಂತ ಅದು ಪರ್ಸನಲ್ ಇಲ್ಲ ಬೇರೆ ಮತ್ತೆ ಇಬ್ರು ಪಾಟೀಲ್ ಇದ್ರು ವಿಜಯಲಕ್ಷ್ಮಿ ಇದ್ರು ಮನೆ ಕಟ್ಟಿ ಅವ್ರವ್ರದ್ದು ದಿವ್ಯ ಕೊಡ್ತಾಳ ಒಮ್ಮೆ ಒಪ್ಕೊಂಬಂದಿದ್ದೆ ಹೋದ ನಮ್ಮ ಮೇಲೆ ಒಗ್ಗಟ್ಟಿಲ್ಲ ಅಷ್ಟೇ ನೋಡ್ತೀನಿ ನಮ್ಮ ಪರ್ಸನಲ್ ಹೆಲ್ತ್ ಗ್ರೌಂಡ್ಸ್ ಬಿಟ್ರೆ ಇದು ಏನದು 10th PUC ಬಿಟ್ಟು ಬೇರೆ ಹಾಕ್ಬೇಕು ಅಂದ್ರೆ ಅವರೇ ಅರೇಂಜ್ ಮಾಡ್ಕೊಂಬ ಅಂತ ಹೇಳಿ ಕ್ಲಾಸ್ ಎಷ್ಟು ಪಟ್ಟಿಗೆ ಬಂದಿದೆ ಅವ್ರು ಒಳ್ಳೆ ಅಂದ್ರೆ ನಂದಿತ್ತು ಅವ್ರು ಬೆನ್ನು ಮಹೇಶ್ವರಪ್ಪ ಅವ್ರ ಮನೆ ಹೋಗ್ತೀನಿ ಅಂತೆ ಈಗ ತಿರುಗಿ ಯಾರು ಬರ್ಬೇಕ್ರಿ ನಾವು ಇವಾಗ ಬರ್ತಿಲ್ಲ ನಾವಾಗ ಬರ್ಬೇಕು ಅವ್ರು ಹೋಗಿ ಬರ್ತಾರೆ ನಿನ್ನ ಆರಾಧನೆ ಪಾಪ ಯಾಕೈತೆ ಅನ್ನಿನ ಹೋಗಿ ಲೆಕ್ಕ ಐತೆ ಅಂತ ಪಾಪ ನಮ್ಗೆ ಅವ್ರು ಬೇಜಾರು ಆಗ್ತೈತೆ ಅವ್ರಿಗಂತ ಬೇಜಾರು ಆಗ್ತೈತೆ ಡಿಮಾಂಡ್ ಬೇಕಂದ್ರೆ ಬರ್ತಾರೆ ನಾನು ದುಡ್ಡಿನ ಅವಶ್ಯಕತೆ ಯಾರಿಗೆ ಜಾಸ್ತಿ ತುಂಬ ಸಾಲ ಮಾಡಬಾರೆ ದುಡ್ಡು ಅವಶ್ಯಕತೆ ಐತಿ ಆದರೆ 50,000 ರೂಪಾಯಿಗಿಂತ ಯಾರು ಏನು ನಿಜ ಆಗಬೇಕು ನಾವು ಒಂದೇ ಟೈಮ್ ಹೋದಾಗ ನಾನು ಒಪ್ಪಲ್ಲ ಹೋಗ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ ಒಂದು ವಾರಕ್ಕೆ ಚೇಂಜ್ ಆಗೋದು ಮಾತ್ರ ಸರ್ ಅದು ಡೆಫರ್ ಕೇಳಿದ್ರ ಇದು ಬಂದು ಮುಗ್ತನಪ್ಪ ಮುಂದಿನ ಸಲ ನೀವು ಹೋಗಬೇಕು ಅಂತ ಹೇಳಿ ಬೈಂಡ್ ಮಾಡಿಬಿಟ್ಟಿದ್ರೆ ಬಂದ್ಬಿಟ್ಟಿದೆ ಅವಾಗ ಮನೇಶ್ವರಿ ಗೀತಾಬೇಕಾಗುತ್ತೆ ಅದಕ್ಕೆ ಅದು ಬೇಡ ಅಂತ ಅದನ್ನ ಒಪ್ಕೊಂಡು ಈಗ ಹೆಚ್ಚು ಹಿಂಗೆ ನಮಗೆ ಬೇಕಾದಾಗ ಅನುಕೂಲ ಮಾಡ್ಕೊಡ್ಬೇಕು ಅಂದ್ರೆ ಬೇರೆ ಮಾಡಿದ್ರೆ ಈಗ ಆತು ಇದು ಒಮ್ಮೆ ತಗೊಂಡ್ರಪ್ಪ ನೆಕ್ಸ್ಟ್ ನೀನು ಬರ್ಬೇಕು ಅಂತ ಹೇಳ್ಬಿಟ್ಟಿದ್ರಿ ಸರ್ ಈಗ ಕೊನೆವರೆಗೂ ಎಲ್ಲ ರೆಡಿ ಮಾಡೀನಿ ಬೈಂಡ್ ಮಾಡೀನಿ ಮುಂದೆ ಸ್ವಲ್ಪ ಮಾಡ್ಬೇಕು ಅದೇ ಚಾಣಾಕ್ಷರ ಐತಿ ಚಪ್ಪಲಿ ಬಿಟ್ಟು ಮಾಡಿದ್ದೀನಿ ಅದಕ್ಕೆ ಪಾಪ ಹೊಡೆದು ಬೆಳೆಸ್ತಿದ್ವಿ ಬೆಳ್ಕೊಂಡು ಹೊಡೆದಿದ್ದು ಕಂಪಿ ಹಿಂಗು ಅಂತಂದ್ರೆ ಈಗ ಹುಟ್ಟಿದ ಹಿಂಗು ಅಂತ ತಿಳಿಸ್ತಾರೆ ಅದಕ್ಕನ್ನ ಹೋಗಿ ಹಾಕ್ತಾರೆ ಬಣಜಿಗೆ ತಮ್ಮ ಎಲ್ಲ ಕಟ್ತಾನ ನಾವು ಪ್ರಾಬ್ಲಮ್ ಆ ಪ್ರಾಬ್ಲಮ್ ಸ್ಟಾರ್ಟಿಂಗ್ ಬಂದಿದ್ದೆ ಭಾಳ ಬಂದಿದ್ದೆ ಒಂದು ಹಂಗಾಗಿ ಬಂದಿಲ್ಲ ಬರಲಿಲ್ಲ ಟೆನ್ಷನ್ ಐತೆ ಯಾಕೆ ಅವಾಗ ಒಮ್ಮೆ ಅನ್ಬೇಕು ಅದು ಸರಿಯಾಗಿ ಒಂದೇ ದಿನ ಒಂದೇ ಬಂದಿದ್ದೀನಿ ಮಂಗಾಪಲ್ಲಿ ಟೆನ್ಷನ್ ನಾನು ಗಂಡನ ಮದುವೆ ಆಗೋಕ್ಕಿಂತ ಬಿಫೋರ್ ಭಾಳ ಚಲೋ ಮದುವೆ ಮೇಲೆ ಅವ್ರು ಲೇಟ್ ಇದ್ದಾರೆ ಬೇಡ ಅವ್ರ ಅಪ್ಪಾರ ವರ್ಕ್ ಜಾಯ ಒಂದೇನು ಮಾಡೋದಕ್ಕೆ ಮಾಡೋದು ಎಕರ ಬಿಟ್ಟು ಗಂಡಂದ್ರೆ ಅವನವ್ರಂದ್ರೆ ಮಾಡೋದು ಮತ್ತೆ ನಮ್ಮ ಎಕನಾಮಿಕ್ ಕಾಪಿಂಗ್ ಮಾಡ್ತಾರೆ ಅಲ್ಲಿ ಬಂದಿತ್ತು ಒಂದು 2 ತಿಂಗಳು ಕೆಲಸ ಮಾಡಿದ್ರು ನಾವು ಅಷ್ಟು ಕೇಳಿದ್ರೆ ಮಕ್ಕಳು ಚಲೋ ಗಾಂಡ ಸಿಕ್ಕರೆ ಏನಿರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ದುಡಿಬೇಕು ಪಡೆ ಚಟಾಯಿ ಮಾಡ್ಬೇಕು ಅವಳು ಕ್ಯಾಪಿಟಲ್ ಅಂದ್ರೆ ಸ್ಟಾರ್ಟ್ ಆಗಿ ದುಡ್ಡಿನೂ ಅಲ್ಲಿ ಹಾಕೋದು ಇಲ್ಲಿ ಹಾಕೋದು ಡಬಲ್ ಅಂತಾವ್ ಮಾಡ್ತಾರಲ್ರಿ ಸರ ಧೈರ್ಯ ಇದ್ರೆ ಕೈ ಹಾಕ್ತಾರೆ ಎಲ್ಲ ದುಡ್ಡಿಗೂ ಬರುತ್ತೆ 10,000 ಅಂತ 20,000 ಅಂತ ಧೈರ್ಯ ಇದ್ರೆ ಬೇರೆ ಆ ಫೀಲ್ಡ್ನಾಗ ಇದ್ರೆ ಹ್ಯಾಂಡಲ್ ಮಾಡ್ತಿದ್ದಾರೆ ಏನು ಮಣ್ಣಂದು ನೆಲ ಸಮಾನ ಆಗೋದು ಸರ್ ಕೊರೋನಾದಿಂದ ಪಕ್ಕನೆ ನಿಲ್ಸ್ಕೊಳ್ಳೋದು ಕಾರ್ ಐತೆ ಅವ್ರ ಕಾರ್ ಐತೆ ಫೈಲ್ ಇಸ್ಕೊಂಡ್ಬಂದಿದ್ದೀನಿ. ಫೈಲ್ ಇಸ್ಕೊಂಡ್ಬಂದಿ ಅಪ್ಪ ಇತ್ತು ನೋಡ್ರಿ. VIP. 2171 ಬಂದಿಲ್ಲ ನೋಡು, ಇಲ್ಲ ಸಣ್ಣದೈತೆ 2171.
It was all of us together we did it.
ಹಲೋ ಯಾರು ಮಾತಾಡೋದು? ಹಲೋ ಯಾರು ಮಾತಾಡೋದು?
ಮಾತಾಡೋದು ಕೇಳಿಸ್ತಿದೆ ಮೇಡಮ್? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್.
ಬಂದ್ಬಿಡ್ರಿ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್.
ಸರ್ ಹೇಳಿ.
ಮೇಡಮ್ ಕೇಳಿಸ್ತಿದ್ಯಾ ಮೇಡಮ್?
ಹಾ ಕೇಳ್ತಾ ಇದೆ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು.
ಸರ್ ಯಾವ ಮ್ಯಾಟ್ರ್ ಅಲ್ಲಿ ಇದೀರಿ ನೀವು?
ನಮ್ದು RP ಮೇಡಮ್, ರಿವ್ಯೂ ಪಿಟಿಷನ್.
ಅಲ್ಲ ಸರ್ ಎರಡಿದೆ, ಬೆಂಗಳೂರು ಮ್ಯಾಟ್ರಾ?
ಅಲ್ಲಲ್ಲ, ಇದು ಗುಲ್ಬರ್ಗ ಮ್ಯಾಟ್ರ್ ಮೇಡಮ್, ಗುಲ್ಬರ್ಗ ಮ್ಯಾಟ್ರ್.
ಕಲಬುರಗಿ ಮ್ಯಾಟ್ರ್. RP ಇಲ್ಲ ಸರ್.
ಮೇಡಮ್
ಸರ್ ಯಾವ RP ಎರಡಿದೆ, ಯಾವ್ದ್ರಲ್ಲಿ ಇದೀರಿ ಹೇಳ್ರಿ ಸರ್?
RP ನಂಬರು 87 ಮೇಡಮ್. ಅಲ್ಲ 88. My apologies. It's 200087 of 2024.
ಸರ್ ಫಸ್ಟ್ ವಿಜಯ್ ಕುಮಾರ್ ಪಾಟೀಲ್ ಸಾಹೇಬ್ರ ಜೊತೆ ಇದೆ ಸರ್, ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಅದು ಬರ್ತದೆ ಸರ್.
ಇದು ಉದ್ದಾರ್ ಸಾಹೇಬ್ರ ಜೊತೆ ಇರೋ ಮ್ಯಾಟ್ರ್.
ಹಾ ಸರ್.
ಓಕೆ ಸರಿ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
Technical.
Technical.
Technical.